but it also presents new opportunities. There is no way, you know, this training room would be as full as it is tonight if it were taking place in person. And that would be true even pre-COVID. We have people from across the state of Virginia, from CASA programs all over the state that are participating. And I love that. And I also love it because we're able to create a recording and really create a library of these amazing resources for families, CASAs, caseworkers, social workers, schools, anybody who wants them. They will be free of charge on our YouTube channel and on our website. So we're so excited. Melissa Waugh has really been a friend to the CASA program and to, you know, the students that we support for a while. She's a special education attorney, which, despite what you may have heard, is not a unicorn, but a special ed attorney, they can be rare to find. So we treasure them when we locate them. She was previously in our area. She had her own special education law firm and also worked with legal aid to offer some of those special ed services. She recently moved to the Nova area. I always forget exactly what corner you're in, Melissa, but I'm sure you'll let us know.
It's Ashburn.
Gotcha. But yeah, we so appreciate that even though you're a little further away, that you're still offering your education and expertise to us to help us build capacity and knowledge in all of our little corners. So thanks a bunch, and I'll turn it over to you now, Melissa.
Thanks, Christy. Yes, my name is Melissa Waugh, and for those who weren't able to attend 2 weeks ago when I gave another presentation, I will just briefly give you my background. I am a special education attorney. I've been practicing special education law for about 10 years now. Before that, I was a family lawyer and guardian ad litem. And the way I came to special education law is my husband and I adopted 2 children from foster care, and they came to us with IEPs. And I was like, oh, what is this? And we went to our first IEP meeting, and they hand you this book and said, here's all your rights. I said, thank you very much. And about 6 months later, I got through the book and realized, what the heck is all of this? And we're expecting lay people, and some of these parents don't even have high school degrees themselves and diplomas, and much less a college degree, and we're expecting them to read all this material, assimilate it, somehow apply it to their unique fact patterns. I just was floored. So anyway, that's when I realized that there was a real need for people, attorneys and advocates, to be able to help parents navigate these crazy waters of special education law. So that's how I got started. I did have my own law firm, and but actually about 3 years ago, joined Belkowitz Law, which is a law firm here in Northern Virginia in Fairfax, and worked in Lynchburg, Virginia. But my family, for different reasons, moved up to Northern Virginia this last summer. But I still work from home, which is nice, even though the firm's only 30 minutes away now. But, and I am technically only part-time. But at the end of the slides that you'll get a copy of from Christy, there is my contact information and firm information. If you have any clients or friends or relatives who might need help with special education law, we have 4 attorneys. 3 of us are up here in Northern Virginia. 1 is in the Richmond area. We serve clients throughout Virginia and to a small degree in DC and Maryland, but primarily we focus on the Commonwealth of Virginia. So we do travel. We also have 2 advocates that are part of our firm as well, which is very, very helpful. So for those, again, who were at the session 2 weeks ago, you may note, if you've received your slides yet, looks like they are posted in as a PDF in the chat now. If anyone wants to open those up and or print them out, I know I always like at these conferences take lots of notes on the slide, so feel free to print those out if you'd like. But you'll notice that I have about half as many slides this time as I did last time. So I don't have to zoom quite as much. And the nature of this presentation is more, you know, in the trenches kind of stories, the things that I see on a regular basis in the field in these various appeal processes that you're not going to find written anywhere. but it's kind of what's really happening in the trenches. So that's really how I view this presentation. So it's a very different format from last time. So I actually will pause more frequently to take questions or your own war stories to share, again, honoring confidentiality in all things. And of course, I can't provide legal advice in this context, but certainly hypotheticals we could address. So with that, let's go ahead and move on. Let me share my screen and we'll get these slides up. All right, there we go. Move this over here. I'm trying to get technically organized here. I want to be sure I can still see the chat. Unfortunately, Christy, I can't see the chat. So whenever I pause or if there's a big question, if you can jump in, because for whatever reason I can't get the chat to come out now. But anyway, all right. So this presentation is about what to do when the school says no. And no actually happens a lot. Sheesh, you'd think they were 5-year-olds because we as parents get no a lot. No to eligibility, or no to a manifestation of a disability, or no to transition plans with appropriate goals. We get no's to all kinds of stuff. I put this slide in to kind of give us a 10,000-foot view of what we're looking at here with special education. So a lot of you are familiar with the IDEA. That's the federal law that created special education. But there are 2 other laws that we very commonly rely on in our field, and that's Section 504 of the Rehabilitation Act and the Americans with Disabilities Act, or ADA. And this Venn diagram illustrates real quickly the idea that children who qualify for special education services under the IDEA, or Individuals with Disabilities Education Act, they also are covered by Section 504 and Americans with Disabilities Act. So there are 2 layers of protection. The IDEA is a funding law. Section 504 and Americans with Disabilities Act are discrimination or civil rights laws. But the children are covered by all of these if they do qualify under IDEA for special education services. If they don't qualify, they most likely are covered under one of those other 2 laws, 504 ADA. So tonight I'm going to start out with IDEA. It is the area that you guys are probably, of all of them, most familiar with. So I'm not going to dig down into all the individual elements so much of the IDEA, but more into the various processes by which we can resolve issues when schools do say no. The 504 and the ADA section is the back half of my presentation. That one I am, because people aren't as familiar with it, I am going to go into, if you'll give me the leeway, I do want to go a little bit into some more of the details on those specific laws so people understand what would be a violation of those laws. And then we'll dig into what to do when the school says no in those areas. And again, these aren't necessarily mutually exclusive. So while there could be claims under IDEA for violations of that law, in addition, there can be claims under Section 504 and Americans with Disabilities Act. And I'll have a slide a little bit later that shows the differences in the remedies. So there are things that you can get or recover under Section 504 and the ADA that you cannot get under IDEA, and vice versa. So it's important to think about these laws as a package, particularly for the kids covered by IDEA. So there are various sources of authority that we rely on when we're determining whether or not there's actually been a violation of the law. Of course, there's the federal statutes and laws, IDEA. We talked about the Rehabilitation Act, Section 504, and the Americans with Disabilities Act. There are a lot of others, but for the purposes of our discussion tonight, these are the important ones. There are federal regulations, and they are found in the CFR, which stands for Code of Federal Regulations. That makes sense. You can access that online. So as I go through this document, I'll have various citations to the CFR. You can cut and paste that into Google, and various producers of various legal websites will pop up with the text of those various regulations. So you can actually from my citations in this presentation, look these things up. There are federal implementing the IDEA, but there are also federal regulations implementing Section 504 of the Rehabilitation Act. And the courts have said many times that interpretations of the law and the regulations for Section 504 and the ADA are the same. I will, at the very end of the presentation, point out a few differences in the ADA world, but in essence, these regulations and laws, 504 and ADA, can be interpreted the same. We also get sources of authority from judicial decisions, such as decisions by a federal judge or by a state judge. While 504 and ADA claims must be heard in federal court, the IDEA, those claims could potentially be heard in state court. As practitioners, we don't recommend that because typically state judges have no experience with special education laws, where the federal judges have a little more familiarity, if not special ed per se, at least the civil rights issues. So the preference for practitioners is that we have all of these heard in federal court, but it is possible for IDEA claims to be heard in state court. And of course, due process hearings. Although unlike federal and state court decisions, which oftentimes you can find online in a Google search, due process hearing, the decisions, if they're reported out, are not easily to find. VDOE reports most of their decisions, but they're not searchable. They're very hard to access. So there are paid services. Special Ed Connection is the one that we use in our law firm, where you can actually find these, but otherwise that is not something you're likely to find on Google. But for the purposes of what you guys would need to know, that's okay. That's not really gonna hurt you. State regulations, in the Commonwealth of Virginia, we do have IDEA state regulations implementing the IDEA. What we do not have, which is a complicating factor, are state regulations implementing 504 and ADA. Other states do, but we don't. And that can make prosecuting those cases a little more confusing and difficult, but we'll get to that a little later, how we overcome it. And the final source is guidance documents from federal and state departments of education, the Office of Special Education Programs, or OSEP, which is in the U.S. Department of Education, the Office of Civil Rights, both the Office of Civil Rights in the U.S. Department of Education, but also the U.S. Department of Justice. Their Office of Civil Rights will investigate complaints arising out of Section 504 and the ADA as well. And then, of course, the Virginia Department of Education. And so all of these agencies will produce guidance documents. Often, U.S. Department of Education and U.S. Department of Justice will produce guidance documents jointly, which is helpful. But you can search their independent websites and get access to those. And throughout the presentation and in the notes, if you hang on to those, the slide notes, I do have web addresses where you can get access to a lot of this stuff. All right, so as I said, I first want to start with the IDEA. There are several common areas of disagreement between the parent side and the school side where these disputes arise. First of all, child find. This would involve failures to identify, to locate, and importantly, to evaluate all children with disabilities residing in the district. Another topic, eligibility, failing to identify a child as eligible under any of the 13 to 14 disability categories that are available. And sometimes these disputes arise over the evaluations that the school did. Maybe the school evaluated the child, but they did a terrible job. They didn't evaluate in all areas of suspected disability. The reports just provide no usable information, in which case the parents have a right to request an independent educational evaluation. And so the way the law is structured for IEEs, or independent educational evaluations, is when a parent requests one, the school has one of two options to respond. They can either say, that's fine, or they can file due process on the parent and defend in front of a hearing officer the school's position that their evaluations were appropriate. And due process is a very expensive process for both the schools and the parents. So it's extremely rare. It has happened in Virginia, but it's extremely rare that a school will actually file due process on a parent. So in essence, in the trenches anyway, there's really only one appropriate response that a school can give, and that is to agree to the IEE. The law does allow for the school to put limitations on who can provide this independent evaluation. There can be distance limitations. In other words, the provider has to be within X miles of the school district, 50 miles, 100 miles that are typical. The private evaluator, independent evaluator has to meet the same criteria that the school imposes on their own evaluators. And I'll tell you where this has become a problem recently, particularly in Lynchburg and other places down in y'all's area, is that they've changed the prerequisites for functional behavioral assessments, which VDOE has said you can get an IEE on that. But what they're doing is they're saying that teachers can conduct these FBAs, which again, VDOE agrees with that. Those of us in the field, and certainly behavioralists would quibble with that. But what the schools are doing to make it harder to get an IEE on an FBA is they're saying that it's a requirement that the person conducting the FBA have a current Virginia teacher's license. So typically when we do these FBA IEEs, what we want is to get an actual trained ABA therapist or behavioralist to come in and observe in the classroom and do this functional behavioral assessment. But it's very rare for someone who has ABA certification to also have a current Virginia teacher's license. I did find such a person there in Lynchburg in Centra Health's autism department, but they're rare. And so there's a lot of tricks in there and probably something that would be ripe for litigation. But IEEs certainly can be an area where there's a lot of dispute because while the schools are supposed to say yes with certain limitations, oftentimes they say no, or they don't say anything at all. They just don't respond for months and years on end. Another common area, of course, is failure to provide a free and appropriate public education to the child. In other words, failure to meet the child's unique needs or confer an educational benefit. And of course, we know after the Andrew F. decision, which we discussed in detail a couple weeks ago, that U.S. Supreme Court recently said that this educational benefit, it's got to be more than some and more than de minimis or a scintilla of value or just barely over the line from zero is what more than de minimis. That's not enough. That is not what Congress intended in providing a FAPE to children. So that is another very ripe area where we see a lot of disagreement as to whether or not, say, an IEP that the school has proposed would actually provide FAPE, or if some failure on the part of the school caused a child not to receive a FAPE. LRE, not quite as common, but it happens. LRE stands for least restrictive environment, and the law requires that a child be educated in the least restrictive environment to the maximum extent appropriate. So schools are supposed to be providing a continuum of locations and ways to provide services. Oh, was there a question?
No, I think if everyone could just make sure to mute themselves.
Okay. Sorry, just didn't want to talk over a question, but anyway, to the maximum extent appropriate, and oftentimes, while they're supposed to provide a continuum of where they can provide these services, either in the general education classroom with all the regular non-disabled peers, all the way down the continuum to providing services in a self-contained environment where a student is only educated with other children with disabilities, or possibly in their home where they're not around any other children at all. That would be probably the most restrictive environment. And so there's supposed to be a continuum, and oftentimes the schools, on the one end of the continuum will say this child needs to be in self-contained, and the parent wants the child to have at least some exposure to non-disabled peers, particularly in the area of socialization, and the school may be resistant to that. Or on the opposite end, the school will say the child's perfectly fine in the gen ed classroom and doesn't need to be pulled out at all. And the parent may be trying to get additional one-on-one services, maybe a reading remediation program or some such that the school is not willing to provide in that more restrictive environment, so the child can actually get what they need. So LRE can go both ways up and down the continuum there. The IEP, failure to develop an appropriately ambitious IEP, that's new Andrew F. language there. Failure to implement it with fidelity. If they say that a student is supposed to be receiving 30 minutes of speech language therapy every week, and we get to the end of the semester and the student has only been on average receiving 30 minutes once a month, that's a failure to implement the IEP with fidelity. And it is also a failure to provide that child a FAPE, because the nature of the IEP, it's like a contract with the parents, and the school and the parents both agree that everything in that IEP, the goals, the services, the accommodations, that all of that is necessary and required for that student to receive a free and appropriate public education. The school and the parent have agreed to that once the parent signs consent. And so now it's a contract. And so if the school fails to implement that IEP, they don't actually provide special education service, they don't actually provide that reading remediation program, they're only providing half of the speech therapy or OT services that were stated in that IEP, that is by its nature a failure to provide FAPE, because the school had already agreed the child needs those things to get FAPE, and if they don't provide it, then they have failed to provide the child FAPE. And then of course there are also various procedural violations. Andrew F. told us that it is possible to fail to provide FAPE to a student based on procedural violations, as long as they do certain things like, cause the child not to receive a FAPE, if they greatly reduce the parent's ability to participate. So it's not the procedural violations alone. For example, what I mean by procedural violation is a triennial. Right? A triennial is supposed to be done at a minimum every 3 years. The school is supposed to reevaluate whether that child still needs special education services. Do they still qualify under that disability category? Have they overcome their disability and now don't qualify under that disability category anymore or for services at all? But this process by law has to happen at a minimum every 3 years. It can happen more often and sometimes does. Sometimes this process will happen yearly if there's a lot going on with the child. But if for some reason the school failed to do a reevaluation within 3 years, let's say they waited 5 years, that would be a procedural violation. And by itself, unless it failed to provide this by missing date, that deadline, that procedural timeline, that somehow it's affected the child receiving FAPE or the parent's participation and whatnot. And obviously those are arguments we would want to make. But these are things that the school can do wrong. They could say no, that could lead to further proceedings. Oops, sorry. And parent participation, again, has to be meaningful. If the school district suggests an IEP meeting date, the parent emails them back, communicates with the school, they're not available on that date, they're available on alternative dates, and the school holds the meeting anyway, that would be a big area of disagreement, because the parent is supposed to have meaningful participation, which means they have to schedule those meetings on days and times when the parent can actually attend. And then discipline is a big area of disagreement where we can need to go on to other levels of intervention. The next two slides are just kind of general concepts under IDEA about what to do when the school says no. And the first concept is called stay put. Now, stay put is a concept that in the federal law. And basically what it means is during the course of litigation, in other words, from the beginning of filing of a due process hearing request. So at that point, the child must stay in the current educational placement, and that's called stay put. The reason the court specifies that is because not every state is as generous as Virginia. In some states, a school district can change a child's placement in their IEP without the consent of the parent. And so this stay put provision was put into the federal law to ensure that if the parent doesn't agree with that change in placement, the school isn't able to do it until the due process hearing is concluded and a decision by a hearing officer or judge is made. But once that whole appeal process is ended, the final decision is made, then the school could change the child's placement in some states without parental consent. But that was the purpose behind stay put. In Virginia, because we do require parental consent to change services, really to change anything on the IEP, certainly to change the child's educational placement. Stay put has evolved to mean something way more than what it does in the federal law. And so when you hear advocates or attorneys, particularly school board attorneys, referring to stay put here in Virginia, what they mean is at the point of any dissent on the part of the parents and the school, that's when stay put goes into effect. But it's really kind of a fiction, because as long as the parent doesn't agree to change the IEP and to sign consent to a new and different IEP, the school does not have legal authority to change anything in that IEP. So it's important to understand that, you know, what stay put is on a federal basis, but also what it means here in Virginia. And let's see what else. So the what I had on the slide here, current educational placement is defined as where all the services on the IEP can be provided. And if all services on the IEP can't be replicated, it's a change in placement. So if for whatever reason the school isn't able to provide, for example, the speech therapy services, then it is considered a change of placement, even if the child doesn't physically move to a different building or a different room. And then there's no stay put under federal law for disciplinary or manifestation determination review appeals. The child will stay in the alternative setting until a hearing officer decision issues or time expires, unless the parents or school agree otherwise. And it's possible that they will. It's possible the parents and school agree on a different setting than what would normally be, for example, a disciplinary setting. Maybe the parents and the school agree to a private placement or some such, and that's possible. Again, in Virginia, the parents have a lot of power in providing consent onto where a child is placed. The other big kind of overarching theme or a concept that I want to discuss up front before we dig into all these various processes is tuition reimbursement. Oftentimes, especially once cases come to me as an attorney, things are pretty much ratcheted up between the parents and the schools. If the parent is wanting the child out of that school district and out of that school building or whatever the case may be, and they want to place the child in a private program to best meet the child's needs, if they ever intend to get reimbursed for that tuition that they've had to pay out of pocket until if and when a hearing officer or a federal or state judge orders the school to pay for that tuition. So everything up until that order, the parent is going to be financially on the hook for, unless they do one of these two things, which will then open up the door, if you will, for the parent to request from a hearing officer or a judge that the school reimburse them for all that back tuition they paid out of pocket, because the failure of the school to provide FAPE to this child, or the discrimination that happened, whatever, happened in the past. And it was but for that failure on the part of the school, the parent never would have had to have spent that money. But if the parent ever wants any hope of getting this reimbursement, at least in Virginia courts and with Virginia hearing officers, they have to do one of two things. And this is stated clearly in the Virginia regulations. Number one, at the last IEP meeting before the child is removed from the public school, the parent must state their concerns about why they feel like the school isn't providing their child a FAPE. And the parent has to state the intent to enroll that child in a private school program at public expense. In other words, I'm pulling my child out of your school, I'm putting them in this private school, and I expect you to pay for that tuition, to reimburse me for that once all this is decided. You know, whether it's decided through informal negotiations and a settlement, through mediation, whatever. That's option one. Option two is called a 10-day letter. That's how we refer to this. But 10 business days before removing the child, the parent writes a letter to the school. And you want to make sure that that letter is received 10 business days before you pull the child from the public school. And in the letter, again, you state specific concerns in detail about the inadequacy of the school's IEP or placement, your basis for rejecting the IEP, which is essentially the same thing, why your child will be damaged if placed in the school's proposed program, and a statement of your intent to enroll your child in a private program at public expense. And that sounds like a lot of detail. By law, you're really not required to provide a ton of detail. It's certainly not, you know, an essay about all the things they did wrong. It's, you know, certainly a couple of paragraphs or even one paragraph summarizing the biggest issues and your biggest complaints about what the school is, or in most cases is not doing for the child, is enough. And then the statement of your intent to enroll them at public expense. So as long as you do those two things, the door is wide open for the parent then to request tuition reimbursement down the road in whatever process might be engaged in. Without doing these two things, the hearing officer or a judge has the discretion to not grant tuition reimbursement. It's not a prohibition. They still have the ability to do it, but it generally doesn't happen. They actually fully expect parents to be aware of this and to comply with one of these two options. So very important overarching concept to understand in dealing with these IDEA cases. All right.
Lisa, could I ask a quick clarifying question about that?
Yes.
So the private placement, I guess I'm assuming that because a private day placement would be funded by FAPT and would, I guess, have to be agreed to by FAPT, and or the IEP team would have to agree to that. So you're saying the tuition reimbursement, if the parent says, look, if I can't get consensus from the FAPT or the school team, the IEP team, then I'm going to, at my own expense, enroll the child in the school, and then I will seek to be reimbursed later. Am I understanding that right?
Well, for the purposes of this discussion, take FAPT out of it because that has nothing to do with the IDEA process. However, let me address FAPT because it's very important and I'm glad you raised it. So what a lot of parents don't realize in the state of Virginia is that the school district itself, as long as a private placement is in the IEP, if it's stated in the IEP that this child needs a private placement or a residential placement, okay, then the CSA, we'll go to the highest level here, but CSA, which of course you have CPMT and you have the FAP teams, but they are required by law in Virginia to pay for that placement. So yes, there's a process, papers have to be filled out, consents to exchange information signed, but there's no option for them to refuse to pay for a private placement or a residential placement in Virginia if it's in the child's IEP. That's the law. And a lot of parents don't realize that. They may feel bad, like, oh, the school district, you know, I don't want to take money away from other disabled kids, and, you know, we would really want it to go to the football program, whatever. It doesn't matter, but that's not how it works in Virginia. It's not the school district that's paying for that private placement. However, all right, exceptions to that. Tuition reimbursement is paid for by the school. To the best of my knowledge, FAPT is not going to go and retroactively pay tuition. They're just going to pay tuition because they're not required to until it's in the IEP. And at this point, that's the problem. The school won't put it in the IEP. That's why there's a dispute. So tuition reimbursement would come out of the school district's pocket. Also, regardless of whether it's in the IEP or not, the other ways that there's a cost to this process to the school district, they still have to pay for any transportation costs. They're still required to provide transportation to and from that private school placement if it's in the IEP. So they would still be on the hook to pay those. And then of course they would lose any incremental funding that would have been attributed to that child being enrolled in the public school. They lose that, federal and state funding. But the cost of the school itself is paid through by fact. Does that answer your question?
I think so. And again, that's an interesting thing, I think, for people to be aware of. I don't think I knew until this year that actually, even if the IEP, agrees that that's what the child needs, then that funding burden actually shifts to FAPT. It is paid for by, a funding formula, but including community money. It's not coming out of the school's budget, really. The school contributes towards FAPT funding, but yeah.
Yes, correct.
Got it.
And a lot of people don't realize that. And it, it's always smart to know where's the money. Show me the money, right? Because it helps explain a lot of incentives that come with various decisions or by a school district, for example. But because of this, and because sometimes it is easier for the schools, right, to just agree to that private placement than to hire more staff or buy expensive programs or whatever. But so there's been a lot of pushback from the legislature and other entities on the number of kids that are being privately placed by public schools. So, the question has been raised, are they shucking off their duties onto these private schools? And then, of course, the CSA money is then paying for that when they should be paying for that out of their own budgets. Certainly a discussion for another day, but so it is an issue. But anyway, but what to do when the school says no? There's 4 official IDEA dispute resolution processes. Well, I should say 3 formal and some other informal ones. So there's informal resolution. So what happens a lot of times is a parent will bring in an advocate or an attorney. A CASA volunteer could be an advocate. There are paid and there are pro bono advocates in Virginia who can go to IEP meetings with a parent. And then, of course, there's also a handful of us special education attorneys that can do that. And oftentimes, and I don't know how many times I've said to parents, if I had a dollar, right, for every time, but it's not fair, it's not right. But a parent can be banging the table for 2 years, my kid needs X, and the school's like, no, you're crazy, what's wrong with you, blah, blah, blah. And I show up at a meeting as an attorney, and all of a sudden, why, sure, X sounds like a fabulous idea. And the parent is just steaming because it's like, what the heck? And it's embarrassing for me because I hate it. It is not how this process should work. It is not a free education if parents are spending hundreds and thousands of dollars on an advocate or an attorney to get what their child was legally entitled to. So it's frustrating, but it's a thing. And so that's one option. Another option for informal resolution is, if as an attorney, sometimes I will send what are called demand letters, horrible term of art, but basically it just says, look, we think the school did these things wrong, and we think it's these violations of these laws. We are intending to file a complaint, a due process request, whatever the case may be. And, but here's the resolution that we're seeking, and can we talk about it? And so sometimes that's a very helpful process. To be able to get the attorneys for the school and the parent talking about resolution, how to get something solved quickly. It's absolutely my preference. I would much rather be able to show up at one IEP meeting and get this thing fixed for this kid and boom, we're done, they got what they need. Or if we can push the ball a little further and get this resolved informally between the attorneys, I am all on board for that. And it's not that I don't want to go to due process or I'm afraid of due process or whatever. It's just at the end of the day, the most important thing is that this kid get what he or she needs as quickly as possible. That's the most important consideration. And so if we can resolve that through an informal process, yay, that's the way to go. But it doesn't always work that way. And sometimes, especially by the time an attorney's brought in, the school district's heels are dug in. Personal beefs and vendettas have now developed between the parents and the school. So it usually is pretty bad. And so options for informal resolution start becoming limited. So then we have more formal dispute resolution processes, such as filing a state complaint with the Virginia Department of Education. The complaint process is a function of states and the education departments by law. The U.S. Department of Education does not typically handle complaints related to an individual student's IEP. They will hear complaints about the Virginia Department of Education screwing up. There was a huge complaint that was decided maybe about a year ago. Correct me if I'm wrong, Christy, but basically the U.S. Department of Education came in and investigated the Virginia Department of Education, and among other things, basically said your complaint system stinks. And it did. And so we're very hopeful that the state complaint process is going to be much more user-friendly and more appropriate than it has been in for the past many years. I mean, it had gotten so bad that many of the advocates and attorneys in our state wouldn't even file these anymore. If parents want to do it, fine, but I wouldn't take somebody's money for it because it was so screwed up. And I'll talk more in a little bit about some specific historical problems. But anyway, but individual complaints for a student, those actually go to the Virginia Department of Education if it's an IDEA problem. Another process is mediation. And the final process is to request a due process hearing. This is an administrative hearing, so it does not happen in a courthouse. And the hearing officer is not wearing a black robe. But in my experience, this process is just like a hearing, a court hearing. There are briefs that are exchanged. There is what we call in the litigation field motions practice. So in other words, the school might file a motion to dismiss. The parent attorney would then have to respond. The school might be able to file another brief. There can be disputes about evidence. There can be all kinds of things. I had one due process hearing. We literally had 7 different motions that I had to respond to prior to us actually getting to the hearing. It was crazy. You will have expert witnesses at this hearing. And so it's important for the person conducting the hearing to know how to actually cross-examine or take a witness, your own witness on direct, or the school's witnesses on cross-examination. You have to know how to question these people. So interestingly, in Virginia, it's not every state in our country, but in Virginia, a decision was made a long time ago that advocates who are not attorneys do have the right to represent parents in a due process hearing. It was always the case that a parent could certainly represent themselves in a due process hearing. It's called pro se, P-R-O space S-E. That was always possible. But advocates can also represent parents in these due process hearings. While agreed, it is better than nothing, and special ed attorneys are few and far between, and it's super expensive. I mean, we're talking, it could be anywhere from $75,000, $80,000 to get to the end of a due process hearing to upwards of $150,000 to get all the way through the end of that process. So it is not cheap to hire an attorney to help get through this. But the reality is, in Virginia, parents very rarely win, with or without an attorney. And there are a lot of reasons for that. Primarily, I think it's the lack of appropriate training for our hearing officers who remain hearing officers. Some of them been 20 plus years they've been on the hearing officer list. And then, you know, they go to 1 CLE per year by VDOE. That's basically a case law update. It's just, it's pathetic. And not to mention the fact there's also a very strong bias among our hearing officer corps towards the school districts and against parents, and it's very obvious. So, you know, a lot of considerations there, but it's important. And what I tell parents is, you know, look, you don't necessarily need me through these other earlier steps in this process, but when you're ready to file your due process complaint, it's time to bring in an attorney or someone who knows what they're doing. For one thing, once you file that complaint, you are stuck with those claims and only those claims all the way up through, if you appeal all the way to the U.S. Supreme Court. The only way to change it is by mutual agreement of the parent and the school board. Okay, what do you think the likelihood is that a school board is actually going to agree for the parent to add claims against their client? It ain't going to happen. Not going to happen. So if you don't get them in up front, you've pretty much lost that opportunity, and you would actually have to start a whole separate due process hearing process for those other additional claims that may have been missed. So it is important to get good advice in that process. And it's important for parents to know and for advocates to know it's not all friendly. Let's all sit around the table and chit chat like an IEP meeting. It is not an IEP meeting. It is a court process-like process that requires some litigation skill to navigate. All right. So digging down into these various processes, first of all, the state complaint process, which under IDEA, as I said, those complaints go to the Virginia Department of Education. It's important to note, especially for our CASA volunteers, that a complaint can be made by anyone. It can also be made by an organization. It could be made by a judge. It could be made by any individual. It does not have to be a parent, does not have to be someone in the school. So it's important to understand that these state complaints can be made by anyone. There is a formal complaint process. You don't just call someone up and say, hey, these people are jerks. There's actually a form, and I think maybe on a different slide, I have a link to the VDOE website where you can get a copy of that form. But this must be a written complaint signed by the person filing the complaint that gives a statement of the violation. You also have to say what you expect or what you would like to see as a resolution to the problem. But so that actually, like I said, has to be written and submitted. There is a 1-year statute of limitations to file a state complaint. And I think I'll talk about it a little more later, but it's 1 year from the time you knew or should have known about the violation, and it's until the Virginia Department of Education receives your complaint. So you have 365 days between those 2 points in time to file your complaint. Due process goes first. And so what this means is if you file a complaint on, let's say, issues A, B, and C with the Virginia Department of Education, and then you subsequently file a due process request, or while U.S. Department of Education has written a dear colleague letter about this, and they frown on it greatly, or if the school files a due process after the parents already filed a complaint on issues A, B, and C, and the parent or the school files on issue A, what's going to happen is VDOE will continue their 60-day process for issues B and C that were not a part of due process, but for issue A, they will toll that, they will hold on to it and not address it until after the due process hearing is over. So it's important for parents to realize that, because if you think, oh, I'm just going to throw the kitchen sink and do everything, well, while you've taken the time and effort to file this complaint, it's just going to be tabled until the due process hearing is resolved. So it's kind of a waste of time. After the individual or organization files this complaint with VDOE, the school will then have an opportunity to respond. And I didn't put it on here, I think it's 15 days, but don't quote me on that. But they will have some period of time to respond to that complaint in writing. And then there will be an investigation by the Virginia Department of Education. Oftentimes the investigator will, or the complaint specialist, they may call the parent and ask for additional information or try to get their perspective or flesh out some more details from what was actually in the written complaint. But they will also talk to the school folks and try to get their side of the beef, if you will, and figure out what's going on from their side. So there's a lot of this ex parte communicating going on between all the parties. It's not just a cold investigation by VDOE based on the facts in the complaint. The VDOE will have 60 days in which to issue a decision on the complaint. And of course, there is an appeal process within the regulations where if you don't like the VDOE's complaint specialist decision, you can appeal that, but it is within the VDOE complaint system. So in other words, it's kind of like the fox watching the chicken house, right? because it's kind of, it's not the same person, obviously, it's a different person within that complaint system who will do the appeal. But pretty much it's all still VDOE. There's no outside entity like the U.S. Department of Education or a federal court that you can appeal this decision to. And I put in there, in that little box there is a link to information. It's a website on VDOE's website. It's a web page that has a lot of documents and things that you can refer to help figure out the complaint process in Virginia. Yeah, I thought I did. And so I did put a link in here so you have the actual web address for the complaint form itself. But keep in mind, you're not limited to the space on the form. You can draft your own response, maybe in the form of a letter or whatnot, and attach that to the complaint form as well. So don't feel like you're limited to the 10 or 20 lines they give you on the form. You can certainly provide much, much more information. You can also attach documents to that complaint form to support your position. All right, historic problems with the complaint. Like I said, for a long time, the folks in the trenches, the attorneys and advocates, we just stopped filing complaints because it just got to be so completely ridiculous. But we're very hopeful. A couple of things have happened. I mentioned that the U.S. Department of Education conducted an investigation and basically told VDOE their complaint system stinks and they need to clean up their mess. Also, within the last 1 to 2 years, an advocate out of Virginia Beach, Cheryl Poe, filed a systemic complaint. I think it was against Norfolk, as I recall, school district. But anyway, but the point is, for a long time, VDOE refused to address systemic complaints, general things that the school districts were doing wrong that was affecting a lot of kids in the school, not necessarily just one student. But Cheryl was successful in prosecuting that systemic complaint. They won that complaint. It was all over the newspapers. You can look it up, Google it up. But anyway, it kind of broke that logjam, if you will, for VDOE, finally recognizing that, oh yeah, we are required by law to hear systemic complaints. And that issue was actually addressed then later in the U.S. Department of Education investigation, that they had not been doing systemic complaints. So that should be fixed. Going back up to the top there of my list, this was huge. And it's the reason why I personally stopped filing complaints for about 3 years. But it wasn't just me, it was many advocates and attorneys across Virginia. What was happening is the complaint specialist, we would file a complaint, and let's say we were upset about issue A, B, and C. And the complaint specialist would then be assigned our complaint. They would maybe call us or write or email, whatever the case may be, and say, or you just, in their response letter, they would say, all right, so addressing issue C, D, and E, we find against you. So they were making up their own facts, changing the facts. They were changing the claims. So they were actually saying, we don't like your claims. We're going to do these 3 claims. Oh, and by the way, now we find against you. When that wasn't even what we were complaining about. It was just absolutely insane. And again, it was systemic all across Virginia, regardless of the complaint specialist, although some were worse than others. So that was a problem. Again, something that was addressed in that USDOE investigation, and we're hoping now is something that will be better. I'm hearing from my colleagues that they are starting to get, we're not seeing that issue anymore, and they're starting to get more positive responses in these complaints. So hopefully this is cleared up. Another problem is unclear guidance about when a complaint is received by VDOE. I literally had a VDOE staff person tell me, because it is possible to email a complaint. You can also fax it in. I typically do both. So anyway, I had actually had a VDOE staff person talking about saying he didn't receive the complaint in time. And he opened the email in that case, about a week later. And he said that it wasn't timely. I said, oh, no, I have this other evidence that shows that, it was there. But despite that, I mean, what are you talking about? What if the complaint specialist goes on vacation for 2 weeks and his response to me was, oh, well, you should have filed sooner. I'm sorry. I'm an attorney, and statutes of limitations and deadlines are a very important thing and something we take very seriously. And so working in an environment where the VDOA staff, complaint staff, couldn't even decide on when something was actually received or not was very frustrating. Again, we hope that this is going to be resolved. I guess, you know, the in the trenches lesson is don't wait till the last couple of weeks of your 1-year statute of limitations to get this filed. But, you know, the problem with that is a lot of times parents don't come to us until way late in the process, oftentimes beyond the 1-year statute of limitations. So anyway, it's, again, an unknown as to how weird VDOA is going to continue to be about defining what is received. We talked about systemic complaints. Another problem is while they have the authority to do so, in our experience, typically the complaint specialist will never order compensatory services. They may find that the school is in violation. In fact, my colleague, maybe about a year ago, had a complaint where it was issue A, let's say, and the complaint specialist found in favor of the school that they didn't violate issue A, but in a footnote in her decision, she said, you know, but school district, you need to be sure that you're not doing A anymore. It was just the most insane thing. You know, so the complaint specialist basically says in the complaint decision, school stop doing this, but then finds in favor of the school. Crazy. And let's see. And also that in general, they seem to address procedural violations and not substantive violations. So, you know, if a school district missed a deadline, they didn't do the triennial within 3 years, or they didn't hold an IEP meeting within 30 days after an eligibility decision to develop the IEP, you know, something like that, the VDOE was, you know, regularly finding against the schools for that. But substantive violations of FAPE, that's something, you know, something that the school did or didn't do caused a child to be denied a free appropriate public education. They were very resistant to those. So, but again, I don't want to sound too negative about this process, because like I said, we actually right now in the special ed community are very hopeful that in light of the VDOE investigation, there's also been an analysis, if you will, by the legislature in Richmond. JLARC has a report out that we also think is going to be very helpful on cleaning up a lot of these dispute resolution processes in Virginia. So we are very hopeful. Don't give up on this, but just understand that there have been problems and they may or may not actually be fixed yet.
And Melissa, well,
yes, let's stop there and do questions.
I also wanted to see, could you provide just a quick at a glance, what is the difference between a procedural violation and substantive violation? I think you kind of talked about it, but just an at a glance definition of each.
Right, procedural would be just a process thing, like they missed a date. For example, like I said, you know, once an eligibility meeting has been held and the school decided, yes, the child is eligible under IDEA. They have 30 days from that date to develop an IEP. Doesn't always happen. And so if they wait and it's 60 or 90 days after that decision before an IEP is ever developed or a meeting ever held, that would be a procedural violation. They missed a specific deadline, for example, versus a substantive violation. So for a substantive violation might be, you know, the school recognized that the child is dyslexic and recognizes that the child is 5 years behind in their reading abilities from their peers. And the school's response to that is basically to say, we're just going to provide 20 minutes once a week of some extra random reading remedial programming. Our teacher's just going to make that up based on, you know, good teaching practices. All right, that's not a there's no date that was violated or, you know, specific requirement in the rule, in the law, the regulations that's being violated. But the point is, a kid diagnosed with dyslexia who's reading 5 years behind their peers needs a, HE double hockey stick more than 20 minutes once a week of some random program the teacher's just throwing together, pulling out of her rear. That's ridiculous. You can't possibly argue that that is providing that child a free and appropriate public education. They should be getting reading remediation a minimum of an hour a day, 5 days a week. I mean, of a research-based methodology like Barton, or certainly an Orton-Gillingham-based program, or something specific like Barton or Wilson, that would be providing that child a fix. So that is a substantive violation of the IDEA. Did that help?
I think so, yes. Does anyone else have any specific questions? I don't think that there are any in the chat that haven't been answered yet. Kathleen, you'd had a question earlier. Did that get answered for you about the year statute of limitations? I'm going to assume yes, unless she pipes in or says in the chat. Okay.
Okay, so let's move on to the next one, which is mediation. And again, in the box there is a link to a lot of documents and information on the VDOA website about mediation. The CFR, of course, are the federal regulations related to mediation. You can Google on the internet. But in order to do mediation, there's a formal request that's made. You can either find on the school district's website or request from the special ed director or whoever your contact is, the form to actually request mediation. And so the parent would fill out, it's a one-pager, fill out that form, and that would be submitted to the school. And then if the school agrees and signs off on it, the school would then submit that form to the Virginia Department of Education. And at that point, the VDOE would identify or pick a mediator to basically do the mediation. They would come physically, probably not now during COVID, but generally they would physically come, and there would be a set date for that mediation, and all the parties would meet together. Typically, most of the time those mediations happen at the school board office. I may have had a couple that actually occurred maybe at the school itself in a conference room, but typically, again, it's not something happening in a courtroom. It is way more informal than due process. Basically the sides just, the parent says, here's what I'm upset about. This is what's going wrong. Here's my evidence that I want to lay out. This is what I would like to see happen. Then the school board kind of presents their side and says, this is why we think we're perfect and we did such a great job. We don't think you need all of that. And then typically you would break out into separate rooms. The parent and their attorney or advocate, or just the parents alone, would go to one room. The school people and their attorney would go to another room. As always with an attorney. I've never done a mediation that didn't involve a school board attorney. And then there'll be a shuttling back and forth of offers. And sometimes the mediator will find that it's important to bring all the parties back in a room together to hash something out. Not always. Generally, it's a back and forth with the parties in their separate little rooms, trying to hash out what's something that both sides can live with. And in general, with mediations, if both parties walk away, a little dissatisfied with the result, it was probably a fantastic mediation. Generally going in, you realize the school's not going to get everything they want, the parent's not going to get everything they want, but it's going to move the process along and we'll get somewhere. That's how it's supposed to work. Again, in general, over the last 3 to 4 years, we saw a real decline in the quality of the mediators for some reason and their ability to get things done. It wasn't just me, it was other of my colleagues found that where in the past, if we went to mediation, something would happen. How good it was for our client would vary, and rarely the parties would walk away because they, couldn't come to consensus, but there was always some debating back and forth of trying to resolve this in good faith. And what started happening is that the school district would come, the parent would be prepared. These mediations typically last all day. I mean, you're looking at 8 hours to expect. Usually we work through lunch. And so the parent would do all this preparation, as you can imagine, for that mediation, present their case, and the school board would just say, yeah, we offered you an IEP, that's it. And there would be no breakouts, no shuttling back and forth. It was just, yeah, we offered you an IEP, take it or leave it. And again, huge colossal waste of the client's money if they've hired an attorney or advocate to, prepare for that mediation and show up that day. So anyway, but again, I'm hearing that within the last year, with all these new things happening, the JLARC, the USDOE report, that this is changing and that advocates and attorneys are having more success with mediation again. But for many years, this was my go-to process because I found it to be very effective. Generally, the school board's attorney is involved at that point. And again, show me the money, right? What's happening with the money? These school board attorneys are not cheap. They're making in the neighborhood $300 to $400 an hour. All right, they are not cheap. And so once the school board's got money on the barrel that they're paying their attorney to prep for this thing and to show up and spend 8 hours with this mediator, they're highly motivated to make something happen. So we can take care of this and make it go away. So this has the potential to be very, very effective. And again, was my go-to process for many, many years. And I'm very hopeful that we're going to start seeing good results again, because this makes sense. This is a happy medium. It's more than just trying to work it out informally or at an IEP meeting. It's a little more serious. The school now has money on the barrel at risk here with time their attorneys are spending, but it's not the humongous financial and time outlay of a due process hearing. So again, this can be a very highly effective process. And generally make sure to miss anything important on these slides. I've talked about the formal request. You can address any matters of identification, evaluation, placement, or FAPE in mediation, but the unique thing with mediation is you can also address any other matters that might arise under the IDEA federal regulations, which wouldn't normally be subject to due process. And there's an OSEP memo that talks about that. Again, this process is voluntary for all parties, parents and school, and either party can walk away at any time. It's also possible for the school not to agree to mediate in the first place. I've never seen or heard of it happening, but that is possible. Again, it's voluntary for all parties. These mediators are appointed by VDOE at no cost to the parent, and they come off of a statewide list of mediators. They are trained mediators. Often in my experience, they don't only do special education cases. They might do postal union cases, or, they do all kinds of cases. So they may have some training and experience, depending on how long they've been doing this with special education law, but really their role is to kind of keep the peace, provide structure for the process, keep the process moving forward. That's really the function of the mediator. Mediation cannot be used to delay a due process hearing. Let's say you file a request for a due process hearing. It's not too late at that point to enter into mediation if the parties choose to do so. But if that happens, it cannot delay the whole due process hearing timelines. The mediation has to happen quickly. And let's see, confidential. So the other thing I've said to my clients in the past, because by law, this mediation process is confidential. So we can't talk about anything the school says in this mediation, and they can't talk about in court or otherwise anything that we might say in this mediation. So I also advise parents in the past, particularly those who didn't have a lot of personal resources financially to pay an attorney to do all this. I'd often help them prepare for it, but let them go on their own because the risk was low. If they say something boneheaded, it's not like the school can use that against them. Alternatively, if someone from the school division sits in mediation and says, oh yeah, we hate your kid, and everyone purposefully was trying to make sure he didn't learn how to read, we would not be able to use that either. It's a two-way confidentiality street. But it is one of the areas where, unlike due process, I'm perfectly happy to send clients to mediation without representation, but maybe just with some preparation. And a lot of it's based on that confidentiality provision. If we're successful in mediation and we're able to come to some kind of agreement, it is generally expected by the mediators that the parties will draft an agreement right then and there. So typically the school board attorneys, and they're always going to be there, they will have a template that they will then just kind of fill in the details for that specific agreement and then have that printed and available for the parents to sign. Parents need to be wary of those if they're not represented by counsel because they like to add in a lot of standard provisions that can really be hurtful to the client. For example, school districts always want to put an agreement, a clause in there that in exchange for this agreed whatever they were going to do, money, paying money, or providing a service, or finding them eligible for an IEP, whatever it is, that in exchange for that, the parent is going to waive all claims, past and future, for this child. I've even had an attorney one time, and I still to this day can't figure out if she was joking, but she sure as heck didn't sound like she was joking. But she wanted us to agree to waive all claims, not only for this one child, but the family had 3 other children and the mom was pregnant. And she wanted us to waive all claims, whether related to IDEA or not. Any claim against the school, not only for this one child, but all the children born or unborn. I was like, are you kidding me? So they get crazy. I mean, that's not even legally enforceable under contract law, first of all. But the point is that some of those little standard clauses that the school board attorneys try to sneak in there can actually hurt the client. There's absolutely no reason whatsoever to waive any future claims. There's no reason whatsoever to waive any claims that are unrelated to the special education services that child might be receiving. I might be willing to waive 504 and 88 claims related to the same situation, but anything else is off the table. Because what if that child is exposed, let's say, to asbestos in a school building and gets cancer? You can't foresee that. What if that child gets sexually molested by a teacher 2 years out, or got sexually molested by a teacher 2 years in the past and you didn't know about it yet? You're not going to waive those claims. So that's one thing to be wary about with these agreements that are signed, especially if it's the school board attorney that's providing the draft. The other big thing that requirement they like to put on the parents that always, is kind of a red flag is that the confidentiality, and that if the parent says anything about the settlement agreement in any form, whether it's on Facebook, whether it's to the neighbor next door, then the school board can basically cancel whatever they agreed to do. They can cancel it. They can claw back any money that might have been paid as reimbursement for something. And so you want to be really careful with those provisions and make sure, number one, that it goes both ways, that the school is covered by that as well. And make sure that I usually try to put specific language that it's okay for the parent to say. Because at this point, all the relatives, the neighbors, the friend in the school who also has a kid with a disability, everybody knows that you're going, that you've been fighting with the school and you're going to mediation, you're trying to settle this thing. Right. So the parents need to have something that they can say, like, well, the issues have been resolved to our mutual satisfaction. Done. But I always try to leave some way that parents have something that's okay to say to people who knew that you were trying to resolve this dispute without getting on the wrong side of these provisions for confidentiality. Anyway, so just some things to be thinking about. But at the end of the day, the idea or the goal with mediation is that everybody leaves that day, even if it's 10 o'clock at night, that everybody leaves that day with a legally binding enforceable agreement or contract. And when we say legally binding and enforceable, it is an enforceable contract. So if there's a violation by either party of that contract, you can go to a competent court has jurisdiction and be able to enforce that contract just like any other contract, just like the contract with your plumber or the contract with your builder or whatever the case is, any other contract, this is enforceable in this exactly the same way. All right, that's my only slide on mediation. Are there any questions about mediation before we go to due process?
Yes. Can we, just to recap, I want to make sure that I'm clear that, so mediation, as far as how to initiate, in your experience, is it usually the school that initiates? Is it the parent that requests mediation? And how do they go about making that first request? I guess would be the first question. Then I have a follow-up.
Okay. I've never seen the school request it, although they could. It's, in my experience, always been the parent, and you have to get the form from the school, and the parent fills it out and gives it back to the school, not to Virginia Department of Virginia. They give it to the school, and then the school decides if they agree to mediate, in which case they would complete their part of the form, and the school would send it to VDOE, which would start the clock and would start the process for getting a mediator. But generally, in my experience, it doesn't take long to get a mediation scheduled, you know, usually within a month, 2 on the outside, but it usually does not take long to get on the mediator's calendar.
Okay. So, and how does, if they're not in this training tonight, how would a parent become aware that they have the right to request mediation? Is that in like the little packet of paperwork that you get? But again, you know, even that language is very dense. And even if you're reading through it, it does, like, it rolls off my brain the first time, like water on a raincoat. You know, it can't quite penetrate. So, yeah, I guess I'm thinking about, you know, the parallel might be like in a court. A lot of times our judges will say at the end of a hearing, by the way, if you don't like my decision, you have the right to walk across the street and appeal. Is this something that like the school is required to tell families at the end of a meeting or something? By the way, if you don't agree with this decision, you have the right to blah, blah, blah.
In certain circumstances, I have had, like, typically that's when you have the special ed director for the school board or school division at a meeting. That person sometimes will say, well, if you don't agree, you can always request mediation, you can always file due process. But typically that's more in a snarky way, not so much an informative way. What they are required to do is to, at every IEP meeting, they have to offer the parent their special education rights. And so there's usually a packet that is handed to the parent. And, you know, after you've been doing this a while, you can always refuse, like save a tree, hang on to that. I've got 16 copies already at home. You know, but that's it. Within that huge document is where they talk about dispute resolution processes. And within that is the information about mediation. So the law expects that parents are going to read these big, huge books about their rights and understand it and process it and apply it to their specific situation without any further guidance from the school.
And what is the relationship? Well, I guess a follow-up question. So it doesn't sound like the mediation form, like to request to start the process of mediation, it doesn't sound like that form is publicly available on the VDOE website. So you would actually have to request it from someone at the school, is what you're saying.
Yes, now it's very possible it's available on the school district's website. You know, if they have a good website with a good search engine on it, you could say mediation and just see if a form comes up. But I've never had a school district balk or refuse to mediate, because normally at that point, I mean, things are really toxic and frankly, they just want to get this fixed and move on. So generally, I don't have resistance once a parent asks for it, but how does a parent know to ask for it? I mean, that's just the pitfalls in the process that our government has set up for helping kids with special needs. Is you got to read that huge book, or you got to have a friend, or somebody mentions it to you, or a kind teacher mentions it. You know.
And what, if any, is the relationship between the state complaint process and mediation? So if you as a parent file a complaint in your child's case, could mediation be like the response that VDOE or the school suggests to try and remedy the issues you've brought up?
It's not something that the VDOE is going to suggest as part of the complaint process. I mean, that's a separate process. They're going to do their thing and come up with a decision about whether the school violated or didn't violate whatever it is you said they did wrong. Now, VDOE is a big proponent of mediation and the complaint resolution process. They want the faster and least expensive and onerous processes to be used by parents and made available to parents. So they really promote these processes, but they are separate. It's possible that a complaint specialist might mention that along the way, but these are really two completely different things. And they're run by different individuals within VDOE.
Gotcha. Okay, that's helpful to know. And then your second point, so talking about what issues mediation can be used to address. So especially when you say that identification piece, can you break that down a little bit more? Because I think you and I have talked that, at least in my experiences of our CASA kids, a lot of times what I feel is the most difficult is getting schools to even test. Like, we can't even get to that point where we can fight about whether the child is eligible or not. We can't even get the child tested. So if we're still at that point where the school is saying, nah, we don't need a test, can mediation be used for that, or the child has to be in the pipeline? Oh, it can be.
Sure. Okay. Sure. Absolutely. Absolutely. Or a complaint.
Okay.
Provide the evidence, because the bar is really low as to when the school is on the hook for testing and evaluating these kids. And the schools want to make the bar really, really high, or they want to leave a child in the child study process for 2 and 3 years. Insane. All of these violations of the law. I mean, they just have to basically have some suspicion that there could possibly be a disability. And certainly if a parent brings in, a report from a doctor saying this child has ADHD, this child has autism, this child has, they're on notice. They have reason to suspect that there is a disability. So they need to evaluate. Parents don't always have these reports, but certainly things like the kid's missing a lot of school, the kid's failing, the kids being suspended every week. All of these are big red flags that the school should be using to trigger this identification process. But as you and I have discussed many times, they don't. Someone to kick them in the pants a little bit and say, aren't you supposed to be following the law?
And this is a great question too that came from the chat, and I'm interested to hear your thoughts on this. So yeah, since many of us, are CASAs that are here, can an entity other than the parent be the one to request mediation, or sort of in conjunction with someone acting in the role of the parent? So whether it's the social worker or the CASA, or as long as, maybe we have a parent in the mix somewhere.
Yeah, for complaints, anybody can do it. But for mediation, you need a parent in the mix. And but remember, the definition of parent is very broad and does include foster parents. So anyone who qualifies under the regulations as a parent could request this, and certainly mediation. If they want to bring, outside, the speech therapist and the ABA therapist who've been serving this kid for the last 5 years and know the kid inside and out to talk, bring them. If you want to bring your special ed advocate or your attorney, bring them. If you just want to bring your neighbor to hold your hand, because it's very intimidating to have, like in an IEP meeting, you got 10 people from the school on the other side. That's fine. The parents can bring whoever they want, just like at an IEP meeting, to come and talk and present evidence or whatever, answer questions.
Okay, that's really helpful. And I would love to hear your answer to this, Melissa, because you've done GAL work. So again, in a lot of our kids' cases, there's a GAL in the mix, but a lot of times it hasn't been my experience that we really see them foraying into this educational side. What, if any, role should the GAL have in representing the child's needs in these cases where a lawyer might come in handy?
Right. Well, you know, unfortunately, the guardian ad litem training does not include training on special education advocacy. I mean, maybe that should change. But so a lot of these GALs really just don't know anything about this, especially if they don't have kids with disabilities themselves, children themselves, that they've had to deal with it, or someone, a friend or a family member who has, where they have some kind of outside knowledge about the process. They just don't really know anything about it or how they could possibly get involved. However, could a guardian ad litem be involved? Well, sure. You know, the guardian ad litem could, you know, in a foster care situation, the guardian ad litem could, you know, encourage the foster parent to participate, or, you know, could be the kind of person who would come to a mediation and sit with them if the GAO was willing to do that. And I think that they would be paid for that time because, you know, they're paid by the court. And so I think that time would be paid. They don't get paid full, you know, rack rate, obviously, but they wouldn't necessarily have to do it free of charge. So they could, you know, certainly help with that process if they wanted to. But a lot of it is just, they're not mandated to do any of this. So it's really up to the GAL how involved they want to be. And a situation, you know, not necessarily related with foster care and that type of environment, but where GALs are involved is in divorce situations. If, for example, there's a conflict between the parents, the bio dad and bio mom, about what needs to be happening at the school. The GAL having an understanding about special ed and how all this works, and most importantly, understanding that only one person who qualifies as a parent needs to provide consent. So this is a problem when divorced parents are fighting. You know, it could go either way, but, you know, let's say mom is advocating for services for the kid, dad just wants to be a tutor and just, you know, says, you know, signs off that no, the child isn't eligible, or signs off on an IEP that is woefully inadequate, that the mom has been fighting for 6 months over. You know, these things happen, and a GAL could get involved in those matters and try to, you know, to get either the court to order the right thing happen, or the court to order one parent or the other have sole legal custody to make educational decisions. We call it sole educational decision-making authority. That is possible. I have a case right now I'm doing of that. So anyway, that's the other way GALs can be involved in those other scenarios in divorce and custody cases.
Okay. And then last question, and sorry, I know we've camped out on this one for a while, but I feel like probably most people in the training tonight are probably going to be involved more in this and or
Sure.
perhaps the complaint rather than like the due process hearings, which I would, want to leave to an attorney anyway. In mediation, so if parental rights have been terminated for the child and the child is not in a family like foster home situation,
ward of the state,
right? Can DSS act as the parent? I know they're not supposed to sign IEPs and things like that, but for the purposes of this, I'm thinking of like juvenile detention settings, group homes, residential treatment centers.
For some, no GALs cannot. They're specifically excluded. Cannot be the parent. I am trying to remember. Seems like, and I apologize, I don't have this at the tip of my fingers. I should, but it seems like that the social workers cannot act as the parent, even though DSS has custody. I'd have to go back and double check that. But there is a process, a formal process where a substitute parent can be appointed, and all those rules and regulations are in the Virginia Department of Education regs. But that is a possibility if there was a situation where nobody could serve in that role.
Gotcha. Okay, perfect. And so just to recap what you have told us about this slide, the short version is mediation has a goodish chance of successfully resolving the situation. Is that what you would say is the short?
I do. Yes, it got bad for a while, but from everything I'm hearing from my colleagues, it's better. And I just feel like, you know, VDOE really got slapped within the last year. And so, you know, they're cleaning up their act. And so these dispute resolution processes that should be robust and should be helpful and easy for parents to navigate are starting to become that way again.
Awesome.
So I would absolutely pull the trigger on any of these options again.
Okay. And Melissa, would it be correct to say mediation or the state complaint process can be used to address issues in an individual student situation, but also the state complaint process could be used for systemic issues or trends as well, whereas mediation is just focused on one child situation? Okay, got it. Okay.
Okay. So due process, as you said, it's not likely to be a process that you guys would be leading the charge on, but it is possible you guys could be involved as a witness in the hearing or as a support person or in the hearing, whatever the case may be. So let me just kind of blow through some of this information just so you know about it. A due process hearing is an evidentiary hearing. We're presenting evidence, whether it's testamentary evidence, that a witness up on the stand being examined, or if it's documentary evidence. We present that on the record before an impartial hearing officer. An impartial hearing officer is a legal term and not always a fact in the trenches, as I mentioned earlier, but you know, we do the best we can for what we have. Due process can be requested by the parent or the school, and the burden of proof falls on the party bringing the complaint. But 99.9% of the time, it's the parent, and so the parent bears the burden of proof in these cases. For unlike with the complaint system, with due process, there is a 2-year statute of limitations, and it can be longer if somehow the school misrepresented what the parents' rights were. Maybe they just never gave the parents a copy of their parental rights, or they never, this actually happens, they never gave the parent a copy of their parental rights in their native language. Then these are reasons why that 2-year statute of limitations can be told, and you can file a request beyond the 2 years from when it happened. But those situations are rare. I mean, really, we're bound by that 2-year statute of limitations. And again, I mentioned earlier, issues not raised in the complaint cannot be raised at the hearing or on any appeal at any level. Due process, same kind of things as the complaint. Due process is available to resolve disputes relating to identification, which we talked about as child find, eligibility, change in eligibility, termination of any service, evaluations, if you're not happy with the evaluation, or if an IEE is refused and the school doesn't file due process, or if the school is putting unreasonable limitations on who can perform an IEE, these are certain things that could go to due process. And of course, the educational placement and services that are being provided to the child, not only services and a placement within the school division, but also that would include private placements, and of course, FAPE. It is the IEP that's developed. Would that IEP confer a FAPE upon the child? Would it provide the child a free and appropriate public education? And also, once that IEP is developed and the IEP arguably provides FAPE, did the school actually implement the IEP with fidelity? And do what they said had to be done to provide a FAPE to that child. So these are the kinds of issues that we would bring in due process. And hearing officers have the authority to issue subpoenas, typically for witnesses and documents. And however, there's no teeth in their authority. And so this can become an area of a battle, and because schools don't always want to cough up witnesses or cough up documents, or they'll say they provided documents and then you know darn well they didn't. I even had a case where we went 9 rounds and about certain documents they didn't turn over in the subpoena in response to the subpoena, And then we get to the hearing, they give us their 5-day binder of documents, and they're in there. Oh my gosh, they're incorrigible. But anyway, so not a lot of teeth with the hearing officers, but there is the option that the subpoena could be enforced through the circuit court. But due process hearings are on such a tight timeline, and parents, you know, frankly, they're spending so much money on this already. You know, the likelihood someone actually is going to go to circuit court to enforce the subpoena is really low, but it is there. Hearing officers can exclude certain evidence and testimony, so they decide what's in, what's out. And they will enter a disposition or decision on every issue that was raised in the complaint. They're required to do that. So once the parent has filed their due process request, or their attorney filed it on their behalf or advocate on their behalf, the hearing officer is appointed by the state within 5 days. So you'll know pretty quickly who your hearing officer is going to be. The school board then has 10 days within which they file their written formal response to the due process request and all the issues that were raised. There's a requirement in the regulations that we have a resolution meeting. It has to be within 15 calendar days after notice of filing the due process request or complaint. And typically the attorneys, I won't say typically, I would say it's intended that the attorneys would not attend this resolution meeting. Although in my experience, the attorneys have always been involved in the resolution meeting, and it's really treated more like an informal mediation, where we have an opportunity, and it's happened multiple times, to actually develop a contract, an agreement that resolves the case, that settles the case. But technically, the way it was designed and intended to work is more like one more IEP meeting before we actually go through this whole due process mess. And that typically attorneys would not be present. The school board attorney certainly would not be present if the parent's attorney was not. But it would be just one more chance for the parents and the school folk to get together and try to work it out on their own. But if there is resolution from the resolution session, what is supposed to come out of that is a written signed settlement agreement, the contract. Either side can void it within 3 business days. And there is confidentiality is not mandatory as it is in a mediation. Mediation, there's no choice. It is confidential. In a resolution meeting, confidentiality is not guaranteed, but that can be made a part of the agreement that the parties would enter into, that the session would be confidential. But anyway, a little difference there from mediation. Also at this point in the due process proceedings, that the parents do also have the option to request mediation. The school can request it too. But again, all the same rules apply. Both parties have to agree. But if VDOE knows that there's a pending due process hearing, they will greatly expedite the time in which a mediator is appointed and the mediation can occur. Because as I said earlier, mediation cannot delay this, very relatively short compared to a legal proceeding in court. It's pretty short timeline, and mediation can't delay it. So VDOE is very cognizant of that and works really hard to make sure mediations can happen quickly. But again, in my experience as a practicing attorney, we typically, myself and the school board attorneys, treat the resolution session as a mediation without a mediator. And it saves the parents tons of money to do it this way. And I wouldn't say all the time, but a lot of the time we can resolve and get to a written settlement agreement at the resolution session. There is an expedited due process hearing process for disciplinary matters. If in that case, this is a due process request arising out of a disciplinary matter, the hearing has to occur within 20 school days of filing. That is lightning fast. And then the hearing officer has 10 more school days after the hearing to provide their written decision. And the mediation or resolution, all that has to happen within 7 calendar days of the school and VDOE receiving a copy of the complaint. So it is definitely expedited. It is lightning fast. The hearing officer decision, it's always in writing. They will provide findings of fact and conclusions of law. And a non-expedited hearing, the hearing officer, it's weird, all these calculations of dates. And I hope, if I didn't, Christy, send me an email later, I was intending to include in all those documents I sent for you guys to have, something that I've drafted up and use to try to keep track of all these deadlines within a due process hearing. It's a one-pager that I think would be very helpful to kind of see it all in one place. But non-expedited hearings, the hearing officer has 45 days after the resolution period ends, which I believe is 30 days, to be able to finish the hearing and get to their decision, get their decision submitted. Expedited hearing, it's 20 days. Excuse me. The other thing about these due process hearings is they're on the record. There will be a transcript made of the due process hearing. And in the case of under the IDEA regulations, the school board is required to pay for that transcript and make a copy of it available to the parents, which is great because these babies can be very expensive. Due process hearings, I mean, the shortest I've ever heard of is, 2 or 3 days. Mine have been, in the 5 to 10 day range. So, I mean, these are not short, and transcription services are very expensive. So it's a good thing under the IDA regulations, the school board has to pay for that and provide it to the parent, because you absolutely have to have it if you're going to appeal the hearing officer decision. I will note now, so I don't forget later, but under Section 504 and ADA due process hearings, the school is not required to pay for it unless they put it in their, and they don't, unless they put it in their procedures, policies and procedures for these hearings. However, by not mentioning it, I have had school districts pay for it anyway, and I'm not going to say anything about that, but technically they're not required to in those. For appeals, if you don't like the hearing officer's decision, you have 90 days, 3 months to file in federal court your appeal, or 180 days to file in state court. And as I said, practitioners in this field, we prefer to go into federal court with these IDEA, 504, and ADA cases, because these judges have a lot more experience. Generally speaking, the only time we go into state court is if the due process hearing happened before they hired us and we just couldn't meet the 90-day deadline. But state court is an option. All right, before I get to this next slide with these remedies, any questions about due process?
I think we're good. Keep on cruising.
Okay. All right, and real quickly, I just want to mention, because I know this slide was in our presentation 2 weeks ago, but the big difference between remedies between IDEA and Section 504 is that you can get expert witness fees and you can get monetary compensatory damages. But you do have to show intentional discrimination, which in the Fourth Circuit, which covers Virginia, means you have to show bad faith or gross misjudgment on the part of the school, which isn't always easy to do. In neither case can you get punitive damages. You always hear about those multi-million-dollar, spilled McDonald's coffee on you and burned yourself and you got multi-million-dollar settlement. That's punitive damages. That doesn't exist in special education law. I will note for the record that under the law, the school can also recover litigation costs from the parents and the attorney if the underlying action was frivolous, unreasonable, or without foundation. This is extremely rare. It's only in extremely egregious cases. I don't know of anywhere an attorney represented a parent off the top of my head, but generally it's where parents have filed over and over in a due process over and over and over against the school on exactly the same claims they kept losing on. Those are typically the ones that I saw. But it's important for people to know that parents and attorneys can be held liable if they lose their case, if the school is found to be the prevailing party. In other words, the prevailing party can recover attorney's fees. And to be the prevailing party doesn't mean you win on everything, but you win on, say, the majority of your claims or the biggest claim out of, if you had some minor things and you lost a couple of those. But once it's determined who the prevailing party is, that party could potentially recover fees from the other party. But for the school to get it from the parent, it's only in the situation where the action is, in addition to losing the case, your action was also frivolous, it was unreasonable, it was brought without any, legal foundation. All right, and again, some of these documents Christy's going to send to you. I commend Rights Law to you as a great resource to search on various topics. If you want to find out, is this a violation of the law or not a violation? This is a good resource to go to. Couple of other quick options that you can find information on the VDOE website about. There is an ombudsman for special education. It's a person at VDOE you can call up and be like, is it right that the school can do X, Y, and Z? They can be very helpful on general questions. They can also explain the various dispute resolution processes, but there are limits to what they can do. There's also a relatively new process in Virginia, which truthfully I haven't actually done or known anyone who's done it yet, but it does exist. And it's the Facilitated Iep Process. It's where there's a form that the school and the parent can request a facilitator from VDOE to assist with the development of the IEP. They come to the IEP meeting, they help make sure things are moving forward. It's kind of like a mini mediator coming to your IEP meeting is kind of how I interpret this. But anyway, but it is an option that's out there. I wanted people to know about. All right, Section 5 of the Rehabilitation Act, I really wanted to do a little review. We don't have time for it. The big thing is it's different from IDEA in the fact that equal access is important. That, let's see, scooch down. Important terms are, things that the school is doing for a child with disabilities has to be done as adequately as the non-disabled. It's equivalency, it's equal access. These are the things that you're looking for. Under Section 504 and ADA, in the regulations, there are very specific things that the federal government, the U.S. Department of Education has said, these are examples of discrimination if they do these things. And I'm just going to commend these slides and also the slides from a couple of weeks ago to you on what those are. But this is different from IDA in the fact that the federal government has said, this is what we mean by discrimination. This is what, if they're doing this, we consider this to be discrimination, in which case you would have a viable complaint. So under Section 504 and ADA, because they're the same, you have several dispute resolution options. Informal resolution, really basically what we talked about with IDEA. Instead of filing a complaint with VDOE, instead, the complaints are to the federal government, to the U.S. Department of Education or the Department of Justice, Office of Civil Rights. There is a quasi-mediation process in there. I'll talk about it a little bit more in a minute, but there's not a separate mediation process like there is under IDEA. Most school districts will have a local appeal or grievance process. These grievance processes are very short, like 30 or 60 days on the outside, which is crazy. Parents usually don't know what train has hit them that quickly. But it doesn't matter. You don't have to exhaust the grievance procedure to do other things. The jurisdictions, the school districts have an option. They can either adopt the Virginia IDEA regulations to apply to Section 504 and 88 claims, in which case mediation, due process, not complaints, but all of those things would still apply, and you would do the same things like you did for IDEA. But they have a choice. They can do that, or the local school district can create their own procedural safeguards governing 504 and ADA complaints. You guys have probably seen, or from what I've talked about, the procedural safeguards for parents. I mean, it's a booklet. It's I don't even remember, many pages long. These, what I have seen when the school districts develop their own policies and procedures, they're typically 1 to 2 pages. That's it. So as you can see, you have a lot fewer rights and things aren't spelled out as clearly when you have the school districts adopting their own. But of course, they design it for their own benefit because their attorneys are the ones who draft them. But you got to figure out what it is in your school district, and you got to apply with those timelines and procedures. But there is a possibility for a due process hearing. And then of course, depending on that decision, you could appeal that decision to state or federal court. I will say that some, if not all, at this point of our hearing officers in Virginia have taken the position they do not have legal authority to hear 504 and ADA claims, which is completely bogus, but whatever. But that's fine. We still, when we file a due process complaint, we still file those claims either as part of an IDEA due process complaint or separately, and we draw the objection, right? We draw the dismissal, because to be able to get into federal court, you can go direct to federal court without exhausting any other remedies or procedures like due process or agreements procedure, certainly due process, if the claim that you're making does not implicate FAPE or special education. And the controlling case on that is Fry, and I think I have a citation for it later in the notes. But the point is, the U.S. Supreme Court relatively recently said that if the claim that you're making, if a child can go to a library or a movie theater and make the same claim that they're making against the school against these other entities, then you don't have to exhaust. You don't have to go through due process. You can go straight to federal court. Or if an adult can come into a school building and make the exact same claim against the school that you're trying to make, then you don't have to exhaust. But clearly, in the realm in which we work, everything is related to FAPE. So generally speaking, in the work that I do, it would be extremely rare that a situation would happen that we don't have to go through a due process hearing. So frankly, if the hearing officers take the position, they're just going to dismiss those claims, fine. We've checked our box, we've exhausted, and now we can take those claims into federal court, regardless of what happens with the IDEA portion of the due process hearing. Let's see, there are, let me just kind of drilling down on these real quickly. Section 504 complaints. Again, we talked about who enforces those. It's a 180-day, six-month statute of limitations for filing these complaints. But again, anyone can file them, parent, student, advocate, whatever. But you only have 6 months. There are opportunities for settlement within the complaint process. It's important to note OCR will not review the content of a 504 plan, an IEP, individual placements, educational decisions. They do not want to replace their educational decision-making with that of the schools. They primarily focus on process. Did the school districts fail to comply with the procedural requirement, fail to find someone eligible, that kind of thing. Let's see, OCR will review the identification and evaluation of students, procedural safeguard violations, and incidents where students of disabilities are treated differently. So if you have instances of discrimination, they will hear those. They will also hear cases related to bullying. That's kind of a unique carve out here. There's information here on the complaint process and the OCR case processing manual for the complaint specialists. I'll just let you look over that material later. You can come back to it and get more detail there. But as I mentioned quickly, after you file your complaint, you get a notification letter where the OCR is agreeing to investigate or not and which claims they accept and don't accept. After that, there is a process called Facilitated Resolution, which is like mediations, mediation light. But the resolution agreement that you come to is not monitored by OCR. Later, after the investigation has begun, there is a resolution process that can happen, whether it's during the investigation or at the end of the investigation. If they find fault in the school, those resolution agreements are monitored by OCR, sort of, but they are technically monitored. And there is an internal appeal process within OCR if you don't like the result from your investigation. All right, I already kind of talked about this already. Federal court, at any time, an individual might file a federal lawsuit. But again, this is the whole thing about Fry and when you have to exhaust and when you don't have to exhaust. The big thing to note, however, is in order to prove intentional discrimination in the educational context, a parent must show something more than just the discrimination. They got to show bad faith or gross misjudgment in the Fourth Circuit. And ADA, really the only slides I put on here were kind of the things that are different about what in the ADA regs is considered to be discrimination. So you can look at those later, but it's exactly the same dispute resolution processes. And of course, there's lots of guidance documents, so many of which either Christy is going to forward to you that I sent her, or the links are in this presentation. All right, and it's 1 minute till 8, but just as I did last time, anyone who needs to get off at 8, that is fine. You're not going to offend me. But if you want to stay, I will stay later past 8 o'clock if people have more questions. So let her rip.
And guys, I'm going to chat you a couple of things. So first of all, I am going to send you links to where you can sign up for parts 4 and 5 of this series, the Trauma Responsive Special Education on March 25th, and then Targeting Social Skills and Executive Functioning in the IEP, which is April 1st. I think a couple of you guys already have even signed up for part 5, so that's awesome. The other thing I am going to chat you is the link to the evaluation, in case some of you are on cell phones or tablets where you may not be able to see the chat. I will also include that in the email that I send out afterwards, but if you are able to go ahead and fill it out, then that is great. And also, yeah, if you guys have any specific questions, I strongly encourage you to stay after. Melissa is happy to chat, and Kate especially, I'm thinking of you if you have time, and if you're still on, I think it would be great for you to stay behind. Melissa, maybe while people are thinking of any last questions or filling out evaluations, could you talk a little bit about independent evaluations, how that is a protected right and how parents go about asking for that or when to ask for it?
Sure, absolutely. So independent educational evaluations, or IEEs, are a right under the law and regulations. And the timing of that is you can request that after the school has already evaluated the child or the student. Typically, while it's not in the federal law or the regulations, federal or state, how long you have to request an IEE after the evaluation has been done, we have some case law, and VDOE has sort of chimed in on this and agreed that because there's a 2-year statute of limitations within which the school can file for due process to get a hearing officer to say, yep, your evaluation was fine, that 2 years is also the limit for requesting an IEE, because you have to give, the position is that you have to give the school a chance to be able to file due process. And if it's 2-year statute of limitations and it's beyond that, they can't file. So, so that's the rule of thumb that we use. You have 2 years from the time the school last evaluated to be able to evaluate again. Another interesting thing that comes up is what can you request an IEE for? So for example, let's say that the school evaluated the child on, did an educational evaluation, a psychological evaluation, but refused to do a speech evaluation, okay? So that didn't happen. Can you then request an IE for a speech evaluation? And the case law is yes. Now, if at the time, usually there's a meeting that happens and the components that are going to be evaluated as, you know, are decided upon, and the parent signs a consent form. Yes, I agree for these tests to be done, right? So at that point in time, when you're talking about what tests are going to be done, if you don't raise the issue that you want a speech evaluation done, or you want a functional behavioral assessment done, if you don't talk about it, then it's harder to make an argument later to get the IEE. But so that's why you want to ask, you want to go as broad as possible on what tests you ask for. The school may or may not agree to do them all. That's okay. Let them do what they want, and then you request an IEE for the one they refused. So that's another important point with the IEEs. Again, the schools can put, while really their only response is, that's fine, you've requested it, there you go. They could file due process, rarely happens, but they can put restrictions on who, on the evaluator for the IE. They can restrict how much they were willing to pay for the IEE. That's a difficult thing, because generally speaking, their contractual amount is way less than the prevailing rate. It's not supposed to be, but it often is. The other weird thing that, and I'm dealing with this right now, I just never blow what these people are come up with. But I recently had a parent reach out to me to say that that they had requested an IE, they used an evaluator that, oh, and I need to talk about the list. So oftentimes, let's say I want a psychological evaluation, IEE. So the school will say, okay, here's a list of people that you can use. And sometimes that list doesn't clarify that you're not limited to that list, okay? I don't fight the list. The list is a great idea because usually parents, I mean, they don't know who to send their kid to. They don't even know where to start looking for some of these people, especially an audiologist. What is it even? You know, and so having these lists is not in and of itself nefarious. The problem is they don't often tell the parents the parent can go off the list to find their evaluator. So that's one thing. But the weird thing that was happening was the parent contacted me and said, so, you know, the IEE is done. And I called the evaluator to get a copy of the report and was told, the school district told them that the report wasn't ready. I'm sorry about the report wasn't ready because they had sent it to the school and the school called them back and wanted them to make changes on it. Wait, what? Oh, no. They don't get to modify our independent educational evaluation. So I'm not really sure how we're going to handle this, but maybe.
I was going to say, what would you say if you heard a parent report the school district said you can get an IEE as long as they come to the same conclusion as we did?
It's not independent. So, you know, that would probably be a good state complaint, one I would want to try in the new complaint world that we're living in, which is probably what's going to happen in this current case that I have, because that's just wrong. That is not independent. But anyway, so any other questions on IEEs? Those are kind of the big issues that we deal with.
And just to make it super concrete, so let's say you get the school to agree to the testing process, you guys come together for the eligibility meeting where you review the data and really make the determination, okay, based on this, is the child eligible for an IEP? If the school in that meeting says no, the parents still feel strongly, no, I think they should be eligible, they need one. What should the parent do, like walking out of that meeting? Should they still sign the documents from that meeting? Should they express their intent or their desire for an IEE? Like, what are their immediate next steps?
Okay, a couple things. This is going to be a chance to talk about partial consent. Let's say they found them eligible under OHI for an ADHD diagnosis the kid has, but they refuse to find the kid eligible for autism. And the kid isn't receiving any services at all at this point. So it is possible, the VUE has said, it is possible for parents to provide partial consent. And for eligibility, I've never actually done it on eligibility, but I would presume that, you know, it's worth trying. I think you could provide partial consent that, yes, we agree that he's eligible, but we disagree with the school that he's not eligible under the category of autism, and then move forward with your dispute resolution processes. Absolutely no question with IEPs, parents can provide partial consent. So let's say the school hadn't been providing speech therapy services. They propose a new IEP that includes speech therapy services, but really the kid also needed, you know, certain accommodations, or, you know, or needed OT, and the school refused to provide OT, but you really want them to get those speech therapy services, right? Or more service hours, if that was proposed. You know, there's little goodies in that IEP that the kid needs and you want started right away. You can provide partial consent. I consent to, you know, these new service hours for speech, but I do not agree and provide consent to the denial of occupational therapy services. I believe my child still needs those too. And with that, you can then go ahead and pursue dispute resolution processes on the part that you didn't provide consent to. But in the meantime, the kid's getting what they need, that the school and the parents were able to agree to. So partial consent is a thing in Virginia, is recognized in Virginia. But you said what to do if they don't find him eligible. What do you leave the meeting with? So number one, let's say they don't find him eligible for anything at all. You do not consent to that. You do not provide consent that he or she is not eligible, number one. So you're not signing anything. Number two, if you know for a fact, if they're, you know, if you guys are there as advocates with them, you need to be requesting IEEs. All right, well then we want to, you know, let's say they found him eligible for ADHD, but they didn't find him eligible for dyslexia. And you know darn well this kid's got dyslexia, right? then you want an IEE for a full and complete, but they may have done a psychological and educational, but they glossed over it. They really even do the right tests to confirm dyslexia. You can immediately, you're like, we want an IEE for psych and educational evaluation with an emphasis on testing for dyslexia specifically. Or, if the kid's on the spectrum and has, social problems, and they did a speech language evaluation that didn't include pragmatics, then we don't agree with that speech language evaluation because you didn't even evaluate the child's pragmatics, their social skills, social language skills. So, if you see blaring obvious things that are wrong, you can leave that meeting, at the end of that meeting, request the IEE right there, and get it. If it's being recorded, you can orally get that consent, or if they want to think about it and email something back, fine, but get that IEE process going. Because you're going to need, number one, you might need a outside witness who's on your side. So that's part of the method behind the madness, if you will, with IEEs, is it's a way, and U.S. Department of Education, VDOE, they recognize that. They recognize that the school has free and immediate access to all these expert witnesses, and the parents don't. And the parents can't necessarily count on calling the school psychologist and expect them to provide testimony that would even remotely be helpful, right? And so that's part of the reasoning behind this IEE process, is so that it's an attempt to balance the scales, right? So that the parents can have access to expert witnesses who could testify about the student.
All very interesting. I see Iris has a question in the chat, and I'm going to boost that in a second, but I also wanted to ask you about extended school year services. I feel like this is also another very common area where parents get turned down. Did you want to mention what those were? And yeah, what are some ways that parents can either kind of strengthen their case around that, but mediation would be the appropriate method if the parents say no to extended school year services and the parents or whoever still feels like the child needs it?
They're great. I'm going to put the web address document in the chat. Look at me being all fancy. Oh my goodness. Yeah. All right. This is, there's got to be a way to send it. There we go. So did everybody get that, or did it go to one person, Diana Gordon?
I think it just went to one person.
Okay. How do I drop down everyone? Okay. Sorry. I saw that. Okay. So this is a link to a document on the VDOE website about extended school year services. Here's the common dispute. All right. You'll have school districts who'll say, well, unless we don't have any evidence or data to support that this child is regressing significantly more than a non-disabled student over the summer in the discussion. Okay, so what this document I just texted you says is there's like 8 different reasons why ESY services can be provided, and regression over the summer is only one of them. So anyone who's having issues with a school about ESY needs this document in their back pocket. Because, let's see, page 15, because this will provide them all they need, and you only need one, you don't have to do all of them. So it says, what factors should the team consider? Okay, regression and recoupment, that's one everyone knows about, but degree of progress. So what's the student's progress toward IEP goals on critical life skills? Is this rate of progress not fast enough, justifying having additional services over the summer to try to help make sure that the child can complete these goals before they graduate from high school? What if there's emerging skills or breakthrough opportunities? It's the end of the school year, the kid, just has some significant hurdle in reading and it's a breakout moment. And if we stop now, we lose it and we start, that's a reason. Interfering behaviors. Are there behaviors that need to be addressed over the summer? As well, that could significantly jeopardize the student's receipt of benefit from his educational program during the next year if you don't fix these problem behaviors. And this is a big justification for kids on the spectrum. continue those ABA services throughout the summer, because if they have interfering behaviors, which they all do, then we need to keep working on them so it doesn't jeopardize access to education the next year. The nature and severity of the disability, if you have a kid who's very low functioning autistic or very severe disabilities, very profound, those kids may need year-round services. That is a factor. And then there's other circumstances and factors they put in here. But anyway, so the bottom line with ESY that you want to keep in mind and you want to use this tool is that it's not just about regression. VDOE says there's a lot of other factors that the team needs to be considering. The other thing that's a little annoying, but I'm not really sure what we can do about it, is I have a lot of school districts who will say, well, we really just can't consider ESY until spring. Well, you could. Not to. Even if you're relying on regression, you should have had that data after the summer.
That's a good point. Yeah. Yeah.
You know, but that is something we run into, and there's really, you know, not a big pushback from that other than roll your eyes and like whatever.
I feel like pretty consistently when
before the summer.
Yeah. I just feel like that's one area that on every, pretty much every single IEP of all of my kids, it's, do they need ESY services? No. And it's for everyone, no matter how much they're struggling. And just for those following along who may not be familiar with the term ESY, extended school year services, so children with IEPs have the right, the IEP team needs to consider whether they should be entitled to receive some of the services and instruction from their IEP during the summer. Well, extended school year, it's supposed to be not just the summer, but I think that's mainly when we talk about it or think about it. And it's distinct from just going to summer school. It's like individualized instruction or services in their IEP.
A good point, Chris. Yes, it can be over spring break. It can be over Christmas break. I got students who've received service at ESY over the Christmas break. So it's not limited to summer. Extended school year just means more than the official days that kids are in school. And exactly, it's not, you know, a lot of school districts going to say, okay, sure, he can get ESY. And here's when our summer school program is, these dates. No. I mean, summer school could fulfill whatever needed to be addressed for ESY, but that is one of many, many, many options. I mean, ESY could be attending a week-long social skills camp, you know, in Colorado. I mean, it could be, you know, something that's not even offered by the school, but the school pays for. So anyway, and certainly it needs to be individualized to what the specific child needs, what issues need to be addressed over the summer. You know, it might be Barton tutoring, it might be whatever.
That's what I was going to ask. Could ESY, could it ever be tutoring at like Sylvan Learning Center? Absolutely. And the school reimburses? Okay, that's good to know.
Absolutely. And the school
open mind or creative problem solving. Okay. And then, yes, since Iris did put a question in the chat, do any deadlines or timeframes change if there are a host of changes involved? If the child starts high school, custody transferred from parents to DSS or foster care, parents have never been involved, but now GAL or DSS are reviewing, I think she means maybe the IEP and don't agree, or reviewing educational documents. I feel like this is often an issue, or even one that I see sometimes is sometimes when the child is in foster care, sometimes the bio parent may have a strong reaction against the idea of special education, or again, they may not understand all the ins and outs of what it could bring, or and so sometimes it can be hard by building that buy-in, especially if they're struggling to, you know, emotionally regulate or other issues going on. So yeah, any thoughts?
Regarding deadlines and timeframes, no. Changes in circumstances are not going to change those statutory timeframes. For example, once a child's found eligible for special ed services, they have 30 days to develop an IEP, period. It doesn't matter what happens in those 30 days. Now, you know, like when COVID hit and the school shut down for a while and whatever, I mean, sure, there's exigent circumstances and, you know, nobody's filing due process on that, okay? No. But, you know, the examples that were given would, no, none of that's going to change those statutory deadlines. However, this is where those things would come into play. two things, evaluations. So let's say that, you know, the child was evaluated last year and wasn't found eligible. And in the meantime, some of these things happened. The child started high school, custody transferred from the parents, foster care. Parents weren't involved in that process last time. Nobody was. It was just the school kind of did it. And, but now we've got supports and whatever. Those changes could justify them reopening eligibility again, because generally speaking, the new people involved, whoever that may be, probably have a reason why they want the kid reevaluated. There was additional testing that happened, or, you know, especially when kids go into the system, a lot of times there's evaluations that are done and that. And so maybe new data has come about, or maybe, you know, where the kid's attendance was okay last year when he was evaluated, this year, attendance fell through the floor, and, you know, the child's never there, or he's gotten suspended multiple times, or because of these changes in his or her life. And, you know, so all of those things could influence or justify requesting that they go to eligibility again, to request that the child be evaluated again because things have changed. The other piece is with the IEP. So an IEP, let's say, was developed last May, and but it was terrible, and nobody was involved who knew what they were doing. And you just look at it, you're like, are you serious? You really put that in writing? I mean, there's some that are just that bad. And so now the GAL or the CASA advocate sees this and they're like, you've got to be kidding me. You know, so this change in the student situation absolutely would justify a request for a new IEP meeting, even though it's not been a year. You know, they call it the annual IEP meeting, right? Because they are required by law to meet at least annually to review the IEP. That's the floor. It's not the maximum. So, I mean, it's not ideal, but I mean, I've had clients who've had IEP meetings like every 2 or 3 weeks until they, you know, for a couple of months till they got stuff resolved. So this idea that you can only have an IEP meeting once a year is completely false. And so, like I said, having some major change in the kid's life would absolutely justify calling for a new IEP meeting, where now people who, you know, have an idea of, you know, what's best and what's going on for this kid and what the options are can be involved in the IEP development process.
What else? What other questions do people have? As usual, I've completely dominated the question asking portion. I'm always so curious. But Melissa, I want you to know, you had mentioned in the last session about requesting a draft IEP ahead of time. And again, I had never really done that before, but I love the concept. So yeah, I have a meeting coming up that the school is open to providing a draft IEP. So I'm really excited to see how that'll work. And I really think it'll be very helpful.
I find it extremely helpful because it really helps me see in advance where we're starting, and I don't have to kind of be creative and think of ideas of how to, you know, what would be a better way to word something, or what's missing. You know, sometimes you need a day or two to kind of think it through and get your thoughts together. And so my strategy is I get that draft IEP, I print it out, and I get a red pen. Right? And as I go through the IEP, I'm jotting down notes on the side and the margins, or I'm circling something. For example, the plot, which they call, different school districts call it different things, but the present levels of achievement, right? That section where they're going to put in the evaluation data and you know, what's going on with the kid, the pros and cons about the kid, blah, 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 all the stuff about the kid, all right? That section is really the driving, it's so critical. It's the driving force of the whole rest of the IEP. It determines or drives what the goals are, right? It drives what the services are that the kid needs. It drives the accommodations that the kid needs. So for example, you're looking at this draft IEP and they have the latest psychological evaluation results, which could be a year or two old, that's fine. But the latest psych eval reports, the latest educational evaluation, maybe a speech therapy report. Focus on that, laser focus on that. And say, because if the school put it in there, right, they obviously agree with it. They're not going to debate it. They're the ones that put it in there in the first place. And so if it says in there in that educational assessment that, you know, Johnny struggles with, you know, phonemes and blending and, you know, only has 10 Dolch words mastered, when the expectation is that they would have 50 or 100 at this point. You know, so if they put in specific deficits, ooh, I circle those with my red pen and I write a big G, right? And then I'll, you know, if I have time, I'll make a list of those. And so, and try to provide that to the team in advance of the meeting. And I'll say, look, you know, thank you for providing the draft IEP. And, you know, based on the evaluation data and the, you know, the teacher's observation, teacher said that Johnny can't stay in his seat and is restless. So I'd circle that, right? And that kind of drives the whole rest of the IEP. So if they don't have any reading related goals, they don't have anything related to phonics, right? And that's all been identified in their own draft IEP that's a deficit area. I want to see goals on that. And they can draft, I can help you draft a goal. I've drafted 1 million goals, or you can draft a goal, I don't care. But we need a goal for Dolch words. We need a goal for phonemes and segmenting words. We need a goal for, you know, whatever was in there. If the speech language therapist said this child has an expressive language deficit, right? I want to see expressive language goal. If they say this child is restless and fidgety, I want to see a behavioral goal on how we're going to help this kid manage himself or herself in the classroom. And over, do they need a fidget? So that would then be an accommodation, not necessarily a goal. Is it, we want to empower the kid to be able to ask for frequent breaks. And so now our goal is, you know, Johnny will ask for a break when needed, or Johnny will flash his, you know, lay his break card, sometimes like a little red card, you know, so the kids don't embarrass themselves. So give them these little color cards and the kid just puts the color card on the desk and the teacher knows Johnny needs a break. You know, whatever system they set up, I don't care. But the point is, are we addressing all the deficits and needs that are identified in their own plot, in their own present levels of achievement section? So that's where you start with your draft IEP analysis. And then, like I said, you plow all that through. You know, if the evaluators are saying Johnny needs intensive reading remediation in a small group setting, then we need to see that in the services. We need to see that Johnny's getting, you know, 30 minutes an hour a day of special education services in language arts, or, you know, or reading or whatever it is at that grade level that they're going to call it. But, you know, you want to see if that's being recommended, that flows all the way through the IEP. And again, using that red pen and circling, you know, making a list in the goals section of the ones that are missing, ones that are crazy and don't really address the right thing. You know, you can modify the goals they've proposed, of course, you can suggest modifications. Then if you have time and want to take it to the next level, go back to those evaluations. Because oftentimes those evaluators will make all kinds of recommendations of what Johnny needs that was conveniently left out of the draft IEP, right? Or, you know, a lot of times, you know, if there's deficits in reading or math, you know, it's interesting how they leave out of the psych eval section in their draft IEP the fact that Johnny's got average intelligence. So really, should Johnny be reading 5 years behind his peers? No. It was important that that IEP indicate Johnny's got average intelligence. He's got a 107 MSIQ. He's right smack dab in the middle. Why is he reading 5 years behind everybody else? 5 levels lower, 5 grade levels lower. So, so that's kind of taking your analysis to the next level, where you actually go to those evaluation reports, you read through them. What did the school leave out? You know, if they talk about a deficit that Johnny has, a social skill deficit, let's say, right? Mm-hmm. So the psychological report goes all what kinds of ways about all these social skill deficits. And then in the draft IEP, the school mentioned nothing about any social skill deficits. You want to make darn sure, well, they include that part of the evaluation report in there, or reference that concern of the evaluator. And then again, push that through the rest of the IEP. Are there goals about social skills? Is he getting special education services time to address social skills? Is he working with a speech language therapist on pragmatic language skills? That's something speech language therapists do, but it's the social skills in language that could be helping Johnny. So that goes in the services. We want to make sure that those services are being addressed, the accommodations are being addressed, the you know, the goals that Johnny will make eye contact a certain number of times, or Johnny will initiate a conversation with his peers, you know, whatever it is. But again, that when you're analyzing those draft IEPs, and they're colossal benefit, because a lot of that stuff's hard to do on the fly in the IEP meeting.
For sure.
Helps you be more organized and focused on what's important.
Absolutely.
Well, 9 rounds about, you know, Dolch words when the school completely left out anything at all relate. You know, he's got 7 reading goals. Am I going to go 9 rounds about, you know, is it 10 Dolch words or 20 we're going to expect when the school hasn't even addressed social skills at all, and it's all over his reports? You know, when you know what all the issues are, then you can help prioritize.
Mm-hmm.
And make sure we are not leaving this meeting until social skills is addressed.
Right. What I feel like I see a lot of times is lots of concerns about social skills and the impact in the plop, but then no services devoted to them, and no goals other than one that I keep seeing district to district. And again, a lot of times the place it shows up is like for kindergartners is, Janiyah will sit for 10 minutes in her seat and sustain attention. It's like, oh, that's a terrible goal for a kindergartner.
Kindergartners doing that anyway.
Developmentally appropriate. Yeah.
Well, and certainly we can suggest modifications to goals that don't make pedagogical sense. I mean, like, you know, so we certainly, yeah, absolutely can do that. And I'm looking at the same. I totally lost my train of thought. Maybe it'll come back to me. Sorry. Any other questions?
Yeah. Any other questions, guys? Was this helpful for the people who are following along? And from the names, I recognize we have multiple people who have been involved in education, whether in the classroom or administration level. So it's fun to see folks, yeah, everybody has different lens and life experience that they bring with them that can enhance the discussion.
And Christy, there was oh, you posted it, but anyway, but I do want to address this because in y'all's population, it's important. And you talked about the parents being unreliable narrators. One of the and typically the schools will just, you know, they kind of have this perfunctory check-off list and they'll do all of them. But one component of these evaluations for eligibility is a socio-cultural evaluation. It's done by a social worker. It often can be done over the phone. Sometimes they'll come out to the house, not always. Certainly not during COVID, but that's I think with y'all's clientele, that's an important one to make sure does happen, because that's where you know, a lot of these issues with the parents being unreliable narrators. A social worker knows what questions to ask, can kind of dig a little deeper, may even go so far as to talk to the GAL or the CASA advocate, whatever the case may be. But that can kind of help address this issue of the parents as unreliable narrators. But where it's important that we're capturing this stuff in a sociocultural evaluation is a lot of these kids have trauma issues. And you want to make sure that's being captured, preferably in the sociocultural, but at a minimum, that needs to be captured in the plop, right? That part that talks about where the kid is and pros and cons of kid and strengths and weaknesses and blah, 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 whatever they call it, that section, right? Present levels of performance. That we capture that information, because that again plays into the whole rest of the IEP, and it also plays into discipline for these kids. So for example, I had a kid, this case, it's an old case and it was in the news, but anyway, a kid that was on the autism spectrum, had some PTSD, and basically the school resource officer, so those are the police officers that are in the schools, you know, I think the kid had left the classroom for some reason. That others like, you know, get back in class. It's like, no. And anyway, but what ended up happening, while there was plenty of documentation in the evaluations and had been discussed in the IEP meeting, this kid did not like to be touched. And that was a huge trigger, behavioral trigger for this kid. SRO didn't have that information. And so he basically tackled the kid, held him down. You can imagine where that went from there. Kid ends up being, you know, arrested and handcuffed for over 4 hours. And, you know, so
he was 12, if I remember right.
Completely address the SRO issue. That's a whole nother thing. But documenting in the IEP things like this kid has PTSD. This kid is gonna react negatively if you touch him without, proper setup, and whatever, this kid has suffered extensive trauma. And you don't have to say was sexually abused, these kind of more sensitive things, but using trauma-informed verbiage that, I know you guys have that training too. Getting that verbiage in that IEP is going to be very helpful. Number one, if there's a disciplinary problem and we have to go to a manifestation determination review hearing, right? If a kid is inappropriately touching the child and he reacts and, punches the lights out of the other kid, and now he's the one in trouble, right? That can go a long way in that manifestation determination review hearing if we've captured it in the.
Good point.
While the schools are supposed to look beyond the disability category and beyond the IEP in making that determination, whether it's a manifestation of the disability or not, whatever action, bad thing the kid did, is it a manifestation of disability? They don't always do that. I've been pretty successful getting them to look beyond the disability, but unless it's captured in that IEP somewhere, it is next to impossible to get the team to even consider any of this other data or information or these other reports. So anything like that related to trauma, related to PTSD, if our kids have it, get it in the IEP at all costs. You really need it to be there. And now in some school districts, they're changing the memorandums of understanding between the school districts and the police departments or sheriff departments, and they're requiring, more sensitivity training and de-escalation training. But some of them, not all of them, are requiring that kids that have these issues, that the SROs be made aware of them, which is what needs to happen. I wish it was mandated across the board, but it's not. But certainly having that information noted in the plot of the IEPs can go a long way to protecting these kids down the road.
That's a great point. Even if they don't have the PTSD diagnosis, noting that they have a history of trauma and may have certain triggers or.
Yes.
Did you, and I'm sorry, Melissa, I promise I'll let you go here in a minute. But I was going to ask, so again, just picturing, the clientele that you work with as far as parents may be different than ours, because just by nature of the people who can afford to hire a special education attorney are probably going to be white, middle class, or upper middle class. They probably have processed through enough of their rights and the information to know how to seek out help. Our parents may not be higher functioning, or they may have some limitations, but what does your process look like when you're going over that draft IEP or really preparing for a meeting? What does your communication partnership with the parent look like as you're doing your brainstorming and then making sure that you've captured their input or bouncing off of them?
So generally, I would want to have even a phone conversation with the parent prior to the IEP meeting to talk about some of these things, and mainly to identify what are the parents' concerns. And as you mentioned, Chrissy, at the beginning of this, I did do legal aid work for a long time with special ed. I provided special education legal services to legal aid, and and despite the economic imbalance and often educational imbalance, and of course, a lot of disabilities are genetic. These parents did generally seem to have an idea that something was wrong.
Sure.
Or could fill in some holes, or could provide examples of something at school. So I found that these parents can actually be helpful in providing that information. And certainly, I want to be sure as an advocate that I'm not just running on ahead and advocating for all this stuff that the parents wait, I don't want that. No, I'm not doing that. I don't want my kid doing that. So you got to have a meeting with the client before the IEP meeting with the school to make sure that you're all on the same page. The other thing to keep in mind is if you're dealing with a student who is older, we start getting certainly 16, 17, 18, well, not 18, 18, of course, now you have issues with, you need a power of attorney. The parent's going to need power of attorney once they turn 18 to continue working with the school and for the school to work with them. But anyway, let's say 16, 17, maybe even 15, right? The parents and the advocate or the attorney, we can come up, wow, with this great program, and we're going to place you at this private school, and you're going to get all this extra stuff in the summer. And the kid is like, I'm not doing that. I want my GED. I'm done. Then the parent has wasted all that time. The attorney has wasted all that time and effort that could have been helping another family, where it would have paid off or something really would have come of it. So my point is, it's not just coordinating with the parent. When you're dealing with an older child, you need to bring them into the conversation. Do they even want to go to the private school? Do they even want summer services? Even if it's a fun camp, do they even want to go to that camp? Because if that kid has no buy-in, do not waste your time, effort, or breath. Now, that doesn't mean we don't advocate with the child for things. I mean, many times I've had kids tell me, yeah, I'm done. they've just been so beat down for so many years. I mean, you totally understand why they have that position, right? Like, I just want, my school counselor told me I could just get this GED and I'm done, and that's what I want to do. And unfortunately, I do have schools recommending this to kids quite frequently, which just sends me over the moon. But we just have to, it's about educating the kid. Oh, well, what are the consequences of that? So if you choose that outcome, what does that mean? If you want to go in the military, can you go in the military with the GED? No.
That's good to know.
If you want to go to a 4-year college, we can't do a 4-year college. You'd have to go to community college. And is it all community colleges, or will you have to take some extra pre-classes before they'll actually register for the classes you want at the community college? So it's just laying it. And you do realize that it's not, you show up one day, you take a test and you're done, right? I mean, it's several tests over a period of time. You have to go to class to prepare for the test, and so it's just trying to provide the kids facts about what are the consequences of that decision. And do they fully comprehend and understand that? Now, the one upside that as advocates, everyone needs to keep in mind, I mentioned this a couple weeks ago, but if a kid chooses and elects to get a GED, all right, and not graduate with a standard or advanced diploma, the school is technically still on the hook to provide them services until the year they turn 22. All right, so it's to 21 inclusive. So it's the whole year that they're 21. And if they turn 22 during that school year after, like, I can't remember what it is, it's September 9th, September 12th, something like that. There's statutory September date. But if they turn 22 after that, they still get services the whole rest of that year. All right, so the school's still on the hook. So even if the kid says, nope, it's GED or nothing, and let him move forward with the GED and make sure the parent understands, look, when he does a GED and then he goes to the recruiter and realizes, oh, hey, I really can't get in the Air Force with a GED. What the heck? And he wants to go back and finish, he can.
Wow. And you said that's only for kids.
Wait, let me clarify. Actually, you know what? I'm correcting myself. I think there might, someone told me this the other day, so we'll have to look into it. But I think there might be a statutory regulation in Virginia that once they get a GED, they cannot go back and get a regular diploma. I meant to look that up and I totally forgot. Someone said that to me the other day. So that could be, and part of that is you don't have to know all the answers about the GEDs. I don't know all the answers about the GED, but get the kid to sit down with the parent with the school counselor, because they should know. That's their job to know, and try to get actual facts about what the consequences of that are. But regardless of whether they can go back and get a standard diploma in that issue, certainly the school is on the hook to continue to provide them service, to include transition services. So maybe the school has to, provide them with some kind of vocational training.
Okay. And you said that's just for kids who have been classified as having a disability.
Oh, right. These are kids who have an IEP.
Got it.
And they decided they just want to graduate with a GED. That's fine. But that doesn't let the school off the hook for providing special education services, which include transition services, which could be vocational training until that year that they turn 22.
Gotcha. Very interesting. Okay. And for those listening along, I don't misconstrue my earlier comments. Like, we do need to think about the parent as a partner. And like we talked about in our very first session about, if we're working on a goal to return home, or if the child's going to be placed with family, building the skills of the parent and the family, but also seeing them as an expert on their child as well. A lot of times when we're getting that sociocultural history, I feel like if the child's in foster care, a lot of times we cut out the parent of like getting any information from them. And no, we shouldn't. Like, we should have multiple sources of information that we're collecting from the social worker and the parent and the foster parent maybe, but we don't want to cut the parent out altogether of that information gathering process. They have so much info that they can tell us, and they should be at the table too. So anywho,
and on that, Christy, one thing y'all might think about as an organization and is maybe getting grant money to buy some of those rights law books, like From Emotions to Advocacy would be the main one, because that's a 1,000-foot view of special ed. And writing IEPs and that IEP book that they have that are intended for lay people, and not all parents are lacking a high school diploma, or even those parents may be incredibly smart and it was just circumstances why they didn't get the high school, and are engaged and want to know more about how to advocate for their child. You want to be selective. You don't want to make everybody, because that'd be a waste of money. But, to have be able to get grant money to buy a stack of those books. And when you come across those biological parents or foster parents for that matter, who really are engaged and want to know more, you're right. Generally, these people can't afford to hire an attorney or an advocate. And there's not that many of us out there anyway. So what tools can you provide to them to be value added that's going to help them swim on ahead on their own and to continue to appropriately advocate for their child till they graduate high school?
Absolutely. Because there's a lot of years left after we're out of the picture. And they're going to have to move that ball. And absolutely. We want to empower them. Yeah. Awesome. Okay. Well, this has been great. This is additional, great info for the recording. And thank you guys for hanging on. If nobody else has any specific questions, then we'll let everyone go for the night and we'll see you all at the next session, hopefully. Thanks, you so
guys.
much, Melissa, for your investment of time, both these sessions.
Thanks for asking me. I was happy to do it.
All right. Bye.
Bye.